Good morning, everyone. Welcome to the Thursday, July 31st, 2025 Agenda Meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben, the Chair of the Commission. I'll take the role of the other commissioners who are present for today's hearing. Commissioner Partridge.
Here.
Commissioner Hahn.
Here.
Commissioner Sullivan.
Here.
Commissioner Tuma.
Here.
A quorum is present. We have 4 items on our agenda today. We won't take up the 4th item before, let's say, 11:30. So if you're here for item 4, that will be the earliest we start that item. So item number 1, Mr. Eck, please introduce it.
Good morning, Chair Sieben, Commissioners. Item number 1 is docket number E-002/CN-22-131 and E-002/TL-22-132 in the matter of the applications of Xcel Energy for a certificate of need and route permit for the Minnesota Energy Connection Project in Sherburne, Stearns, Kandiyohi, Wright, Meeker, Chippewa, Yellow Medicine, Renville, Redwood, and Lyon counties in Minnesota. The question before the Commission is, should the Commission grant the request to reconsider its June 11th, 2025 order modifying and adopting Administrative Law Judge Report, granting Certificate of Need, and issuing a route permit for the Minnesota Energy Connection Project? And staff is available for questions.
If the company would please come forward for appearances, we'll begin with Commissioner Tuma.
Yeah, Madam Chair, we'll let the company introduce themselves so they don't have to do it every time. And
Ms. Agramonte, good morning. Please state your name for the record.
Good morning, Chair, Commissioners. Lisa Agramonte from the law firm of Frederickson and Byron on behalf of the applicant Xcel Energy.
Good morning, Chair, Commissioners. Andrew Welch with Xcel Energy.
say that again.
Andrew Welch with Xcel Energy.
Thank you. Madam Chair, and I think it's going to be best for the public if we break these down and have votes on each one of them as we go along. There are some that might take a little bit longer, and we'll probably do them out of order. I just don't think people need to hang around for some of those, maybe the ones that might go a little longer. So, because Agramonte, we're going to start with the Lisa Hoffman reconsideration request. And Madam Chair, I have closely reviewed the record. I think staff's briefing paper reflects what should be the position of the commission, that there really is.
A little louder, please.
Yeah, that there's nothing new for us to consider here, and that the position indicated by Xcel in their filing that this should be denied is fine, and I have no questions for the applicant or the parties, and so I'm ready to make a motion, but I want to make sure other commissioners, if they have questions, are free to ask them.
Commissioners, does anyone have a question for Ms. Hoffman or her representative or the company regarding her request for reconsideration? Hearing none, then Commissioner Tuma moves decision option 1 to deny Ms. Hoffman's request for reconsideration. Is there any discussion? All in favor, please say aye. Aye. Opposed, the motion prevails. Commissioner Tuma.
If we could take up the Cabrera's reconsideration next, Madam Chair. And again, the same thing, I have reviewed all the information provided by the party and by the landowner, and also reviewed the response from the company and reviewed the staff's briefing papers. I think accurately reflect the situation, and that I don't think there's any reason for reconsideration of the request or for us to address anything with regards to our decisions on the certificate of need. So I'm prepared to make a motion. I don't have any questions for the parties or for the landowners.
Did all commissioners review the filings that were submitted, and do you have any questions regarding the Shannon Cabrera reconsideration request? Seeing none, Commissioner Tuma moves decision option number 5 to deny the Cabrera's request for reconsideration. All those in favor, please say aye.
Aye.
Oppose, the motion prevails. Commissioner Tuma.
Next, let's take up a request for reconsideration associated with alternative 23. This is a little bit more complicated. As you know, this was one of the more difficult conversations we had back in when we did the 213, what did I say? 23. Yeah, 213, dyslexic in action, thank you. So it's decision option 10 or 11 that I would like to address next. And I think we should take at least some statements here. There were some indications that some people felt that there weren't things in the record. I've reviewed the record. I think they are all there, but I certainly know that this was a proposal brought for us as an alternative from neighboring landowners, and I think it's worth, since we listened quite extensively to the neighbors who proposed decision option alternative 213 to us, I think it's fair that the landowners that are opposed to it at least give us a chance to state their case. And so, Madam Chair, I do know that we have several folks on there. I know Diane Jensen was the first one to file in the record for it, so I guess we'll start with her. But,
Ms. Jensen, are you in the audience? Great. Could you please come forward, if you don't mind? And we also have listed here Norma Schlemmer, Linda Nesberg, Cameron Leibel, and Matt Morley to speak on this. You're welcome to take a seat if you'd like.
I would grab the middle
And-
seat if you could, because that mic sometimes acts up, and so we don't want you to be in a situation where you're trying to fight the mic.
Welcome, Ms. Jensen. Could you please state your name for the record?
Diane Jensen, Jensen.
And Commissioner Tuma.
Ms. Agramonte and Mr. Walsh, I think you've saw the filings, I assume, from the landowners. There was some concern, particularly from Matt Morley, about getting notice. I just want you to hopefully respond that you feel that they have been given notice. We check back at our records, every indication that they did. So I guess I first want to hear from you regarding that, and then your position with regards to this recon.
Ms. Agramonte.
Chair Sieben, Commissioner Tuma, yes, our review of the records do indicate that these landowners received notice, and the company is continuing to try to work with them now as part of the easement acquisition. We believe that there's nothing new for the commission to consider today to change its mind or that the route selected in this area, and we believe the order should stand.
Thank you. So, Ms. Jensen, you've heard our position. We're struggling with what's new. We have looked at the area. We had discussed your property and pretty extensively. I noticed the exact things that you were talking about in your filing with regards to this new route, that it would not follow the property line over your property particularly, and likely there would be a pole someplace in your property at best on the boundaries, but at best we're talking maybe 3 or 4 poles crossing your field. And so that was a concern, and we recognize that. But so that evidence was in front of us. We had it, but obviously it's your land. Just because we can see it on a map doesn't make it real. I have driven by your property. I looked at it, but I couldn't go out and walk that line because I don't trespass on people's property. This is out in the middle of the field, and so I want to get your perspective, your feel for why we shouldn't do what we actually did.
Ms. Jensen.
You would be welcome. Just ask, and I'll take you to my prairie. I've got several concerns. My prairie is my primary concern, and I want to get to that. But there's also the issue of notice. And the parties affected by the Route 213 change did not get notice of the April 10th meeting. And I went on to eDocket and looked at the certificate of service, and we're not on there. I looked at the final EIS availability notice of January 22nd. We're not on that certificate of notice. We didn't know about it. we didn't have a chance to participate. We didn't know the change was being proposed. It was stated in the hearing that the neighbors were consulted. We were not.
To that point, I just want to make sure, Ms. Agramonte, it was my understanding, you can correct me if I'm wrong, that alternative 213 was part of all the maps and all the public meetings, part of the scoping discussion, pretty extensive. It was brought forward by landowners, so I know these things just don't pop up right before our hearing. But help me out and just confirm for me that this alternative was part of all the discussions in the public at the public hearings.
Ms. Agramonte.
Chair Sieben, Commissioner Tuma, first I'd like to comment that landowners don't get notice of every milestone in the proceeding unless they sign up for the project docket. So the fact that there was not a notice for the FEIS, for example, is not a defective notice.
Ms. Agramonte, can you speak a little more into your mic?
Yeah, I sure can. I'm sorry.
It's just a little tricky.
And with respect to the landowner notice, yes, she was given a project mailing in October of 24 prior to the public hearing, and she has had she participated in the October 29th, 24 public hearing. So Ms. Jensen did have notice and participated. And yes, Commissioner Tuma, 213 was one of the alternatives evaluated throughout the process after the scoping decision.
And let me just make sure I understand, Ms. Agramonte, and what may have happened. In earlier notices to potential affected landowners, people are in the disclosure are given instructions on how to sign up for the docket and how to get notice of future commission meetings. But as a matter of practice, not everyone who's potentially impacted by a project gets a mailing at every milestone, including in our final agenda meeting. Is that what you're saying, and am I correct?
Chair Sieben, yes.
Ms. Jensen, I know that's hard to hear now, but do you understand that or have any questions about that? Part of the problem is that when we're permitting like transmission lines that are this long, for example, you can overwhelm people with too much information of all of the potential meetings and decisions that take place. So as a commission practice, we want Minnesotans to be informed of what our decision making is and what, are important milestones that people want to hear about. But I think what likely happened here and what I heard you say is maybe an earlier notice came saying this could be something that you're concerned about, and you needed to sign up then to continue to get subsequent notices. And that's probably why you didn't get notice of our agenda meeting in April when we made the decision. But again, I also would like to just point out that it is good that you continued to contact us and express your concerns, because we still have a chance to hear them now in this reconsideration request.
I mentioned in my request that I didn't get notices. The Xcel was using old property records, and it was far into the process before they had correct information for me, for my sister, and for my other sister. They got it because I had a neighbor call me and ask my opinion. And I said, "What are you talking about? I didn't know anything about it." So I spent a long time on the phone, calling Public Utilities Commission, calling Xcel, getting transferred, leaving messages. I finally got to Randy Fortis, who confirmed that they didn't have the current property records. They were using old property records that were provided by a contractor.
Ms. Agramonte, what about that? Were you using old addresses?
Chair Sieben, if I could have a moment, the notice that I have in my notes is in October of 24, and Ms. Jensen's participation in that subsequent public meeting. But let me check with my team. One moment.
While she's doing that, if I may add, I didn't go to that hearing because I got a notice. And I said in my statement that I had learned of the meeting another way, not from a notice of the Public Utilities Commission. And when I was there, I did sign up. I gave my name, my address, email, I think phone number. So I think I should have been getting notices after that.
After you were at that meeting in October, correct?
And I did not. And you can see that on the notice of service. And I understand what you're saying. It's a big, complex process and entailing many property owners. But on 213, it was a change that affected brand-new property owners. It affected the three of us sisters, right? Changed it half a mile into our property. But the people to the east of us and to the north of us weren't on the route ever before that. And that would be Cameron Liebel, Tom Morley, Matt Johnson, and Jolene Saman. They had no clue that this was proposed. I had no clue that this was proposed. So we couldn't participate on April 10th. We would have. Let's see. I do want to make a note about the meeting on April 10th. The two landowners who testified said that they had worked with other property owners and had come to an agreement. They did not speak to any of the people I just listed or the three sisters. They did not get agreement. They did not even discuss it.
We'll get to this substantive issue about which alternative to select, and Commissioner Tuma will step us through that. But can we hear from Ms. Agramonte on the, did people get proper notice with new addresses, and then kind of set aside the notice issue and move on to the substantive issue? Ms. Agramonte?
Yeah, Chair Sieben, I understand that this property is property that Ms. Jensen had held in trust or does held in trust. And so there was a change in the property records that hadn't been captured at the time she notified Xcel Energy. It was updated. And that, as I mentioned, she did participate at the meeting in October of 24. If she asked to sign up on the project list, I wouldn't have those records. That would be something to ask the former ERA staff or the PUC staff to see if they received a request.
Ms. Jensen was shaking her head no about the trust, I think.
Yeah,
Is that what you wanted to
property
add?
ownership, that is incorrect. The property was held in trust for my mother before 2001. After 2001, it belonged to the three sisters, undivided interest. So that's about 20 years. And then we separated the properties. And at the time that those notices were going out, we individually owned those properties. It was on record with the county, and they were using old records. Didn't get us. And Randy Fortis told me they were using old records. But for my communication with him, I don't know that we would have been included.
Ms. Agramonte?
Chair Sieben, I'm trying to get information in real time here. What I can say is that the company follows the law and gets the records from the county. I can't speak for Mr. Fordyce. He's not here right now, so I can't refute what Ms. Jensen says Mr. Fordyce said to her. But I will go back to, she was at the meeting in October 24, and I haven't heard Ms. Jensen say that she wasn't participating at that time.
Ms. Jensen, can we move past the notice thing, since we do know you were at that October 24 meeting? And then on to the substance. Commissioner Tuma.
Madam Chair, I want to hear your concern. I mean, I understand We had, like you said, extensive communication with the landowners. I don't think they said they had every landowner agreement. That was not in my mind when we were making the decision. I was pretty confident in the discussions we had back in April in my review of the record that you would probably have a problem with where the line was going to be. And we had to make a judgment between two different options. Okay, and that judgment was we had 5 landowners who were homes, residences versus backfield, which is all factors we have to balance, okay? And so we've had information that was provided to us, Mr. Potter and Mr. Martens, and other landowners on the record. They filed that record. We were able to read it, made a decision on it. You obviously have some concerns that may not have been in front of us. I think I had a lot of that. I think I understood it, but I do want to hear what your concern is. I just want you to know that we didn't think that we were not represented that everybody agreed, okay? We were pretty convinced that not everybody did, okay? So give us your concern.
All the neighbors to the east weren't part of the discussion.
I understand that. I want to know your concern with your property, okay?
Right, okay.
We've talked about this. I have some concerns about that, and we're going to have some conversations about it in a minute of the notice stuff. But I want to know what I'm not seeing on the land that you see because you're the landowner, okay?
My property has remnant prairie on it. And before 213, the route did not cross my prairie. You can't see the prairie from the road. And when it was stated in the hearing that it's just a field there, that's not true. And the person who stated that knows it's not true. He rented that land for many years. He used the prairie as a pasture. It's not bare field. There's prairie there. Prairie is a globally threatened habitat that needs to be protected. It needs to be considered in this decision. Xcel said that, in their response to my request, that transmission right away is consistent with prairie because prairie doesn't have woody vegetation to be cleared. They don't understand prairie. Prairie wouldn't have woody vegetation to be removed. Prairie is a globally threatened habitat of herbaceous plants, of rare plants, and they said that they work with landowners on seed mix. I said in my request that you can't regenerate prairie, you can't replant prairie. A seed mix isn't gonna remake a prairie. So they don't understand prairies.
Mr. Eck, do you have the map from the record? It's a
The
map.
map on page 20 of the briefing papers.
Oh, no,
No?
it's Appendix N85 of the record, the EIS. And I just want to make sure I understand this because that we didn't miss something. If we did, we want to be fair to you. No, that's the wrong map. You had sent me 3 maps from the EIS. This is the Platson's property. I want to make sure. There you go. So enlarge that if you could.
EIS.
So this is from the EIS. This is our record.
Which page?
It's page N85 from the maps. And this is the depiction I saw. So I want to confirm and truth test this with you. And I see on there that there is RIM in Minnesota reserve easement, okay, for the prairie, okay?
No, that's not the prairie. That is something that I enrolled and I planted using prairie species from the remnant. The remnant is north of that.
So why isn't that preserved? I mean, it's not in the record that that was a prairie, that I'm seeing a field here. That's what the record shows me. And they're got conservation easements for Mr. Morley above there. I see all those. I saw the S&A information around the river. Okay. So you're telling me that there is a remnant prairie, but it's not, you don't have it in any set aside or protected status.
It's not protected now. I have talked with the DNR about putting it in the Prairie Bank easement program. We haven't done that. I now wish that we had. The state does recognize it as a remnant prairie. There's the Minnesota Prairie Tax Exemption, and we have that. So we don't pay, now I'm saying we because my sisters and I owned it, but I have owned it now for years. I don't pay property taxes on the portion that's a remnant prairie because it's a remnant prairie, and I have an agreement with the state that I will manage it as prairie.
Yep.
And as long as I do, I don't pay property taxes.
And you're saying, just so I understand, Ms. Jensen, that remnant prairie parcel was never farmed
Never.
for hay as part of what was
No,
represented?
it was grazed.
Or
My family
grazed.
grazed it. The Potters grazed it, but it was never tilled, never farmed. After the grazing stopped, I started managing it for prairie, including burning, removing invasive species, and lo and behold, the remnant prairie persisted through those years of grazing and is now flourishing. It would be a travesty to destroy part of it, to
Mr. Walsh,
fragment it.
are you presently putting structures in that prairie? It doesn't look like it's more than 1,000 feet, but I do see a corner there, a little movement, and usually unless you figured out a way to patent a way to move lines in space, okay, there's more than likely you intended a pole to be in that prairie. I know these are just schematics, and we generally want to follow the line, okay, but I don't know what your discussions have been, whether there is enough space across that remnant prairie not to put a pole. I think there is. It looks like it's less than 1,000 feet, but you can tell me. And then we'll hear from Ms. Jensen. Yes, I assume you talked to somebody that knows more than we do. Ms. Agramonte?
Chair Seaman, Commissioner Tuma. Yes, I wanted to verify that the current locations do not impact the prairie and that the company will commit to not putting a pole in the prairie.
And go ahead. I mean, I'm not trying to follow the solution. I'm just trying to understand the land that's in front of me, and that's kind of what I perceived when we made the decision. And so they're confirming what I perceive, but you can correct me if I'm wrong if there's not a span of 1,000 feet across this prairie.
It's more than just the sighting of a pole.
So it's just the line over it is what you're concerned about.
The easement threatens it because sometime in the future, they would have the right to do what they deemed necessary, and it could be.
Well, no, they
spraying
don't.
it.
I want to correct you there. They do not. Okay. We have a very thorough vegetation management plan that they must follow. And you're planning to follow that, approved by the DNR. We go through a whole process to make sure your vegetation management plan. You're not planning on mowing prairie, are you?
Chair Seaman, Commissioner Tuma. No, nobody's going to mow prairie. The vegetation management under a line is to ensure that there's nothing that will grow into the line. Prairie, as indicated in our reply comments, doesn't have any woody vegetation, so there'd be no need to clear.
Okay,
And
sorry.
Ms. Agramonte, just to have you expand a little more, what about the construction practices during the actual construction that I'm sure Ms. Jensen would be concerned about too? Is it far away from the prairie when you're actually
Yeah,
doing stuff?
Chair Seaman, that's something will need to be planned to avoid the prairie, and I've spoken with Mr. Samuel. That was my sidebar, and they'll work out a plan to not impact the prairie.
Okay, Ms. Jensen, I just want to make sure. I just want to make sure you understood that there is a plan, and it's not to ruin your prairie. Okay,
There is a
and if they
plan.
do, you better complain to that guy. because he'll let me know, and I will be on them to not do that, because I don't want to see them destroying prairie, but I understand that's not going to satisfy you. I know you just don't want the line there, and I'm trying to get an understanding of what we're dealing with. That's what I understood when I looked at this map at the original hearing, that there is something there that is of value to you, okay, and that we could span it. That's what I saw. But I know that's not satisfactory to you now. But tell me anything else that you have that concern part of your land.
I would say it's of value to society because it's so rare. There's so little left. My concern still is in perpetuity, they would have access to that and could do what they do. You can't replant. If they killed it, you can't replant it. Prairies just don't work that way. Let me see. Yeah, it's very important. And, in the April 10th hearing, Mr. Potter said, let me just make sure I get this right. We just want it to go a little bit further away, that's all. And it was moved half a mile and suddenly affected new additional property owners. It could have been moved less. There are other ways to get it away from those homes and away from Mr. Potter's home that doesn't cut half a mile north. They could zag down to 310th Street, somewhere on Potter's property that's not near their home. I don't see that it needs to continue straight across.
We appreciate that, but that's why we do alternatives. That's why people give us alternatives. And usually if there's an alternative proposed by landowners, we will consider them, always consider them. These are the two decisions that we had, two routes, two options, okay? And there were plenty of opportunities to give other routes and get them in the record, and we would have considered them. I'm given two routes. I drove that area. There were spots I looked at and go, gee, maybe this would be better. And then you look down the road and, oh, there's two more houses down there, okay? So there's a lot of things that we could have considered all over. But the decision we had was alternative 213 or the initial proposed route. I think they consented to do either, is what I think the record indicates. And Mr. Potter and Mr. Martins had this route and showed us the concerns that we had. So I'm hearing from you. Are you speaking also for your sisters too, or
I think some of the other participants
other participants?
are online and may want to speak.
Yes.
And Linda Nesberg is here as well.
Oh. Ms. Nesberg, did you want to provide any comments or just here for support? Okay. Why don't you go to her left over there, please, because that microphone works better. And there's a little button on the bottom to turn it on, and then you have to speak close to the microphone so folks online can pick up the sound. And could you state your name for the record, ma'am, please?
Linda Jensen Nesberg. When I got the first maps of where the poles were going to be along the road, I thought, well, that's livable. And then after that April 10th meeting, I get a new map and it's moved in. And I thought, wait a minute. Well, how did that get moved without talking to anybody? And listening to you talk now, yes, you had what was given to you at that time. But know that Mr. Potter didn't talk to any of us. He did not. And so you had two options without our input. My choice would be bring it back on the road.
Closer to those four residences, though?
No, Mr. Potter's house is here, and it goes along here. It can come back down and on the road.
There is a whole mile between Mr. Potter's house and my property line.
That would still affect Mr. Morley's concern? And we did talk about
Not
the,
sure about that.
we did talk about expanding, the route here, okay? And it came to a conclusion that there was one potential residence that could be impacted, and so we kept the route where it was and expanded it to the east, okay, to affect the one known landowner that would be affected, or homeowner, I should say. It's inappropriate to say landowner, the one homeowner. And so they're expected to be working with Mr. Martens and his neighbors, okay, which I'm hoping that you're doing. I'm looking at you, trying to get eye contact to make sure you're having those conversations to fix that problem, okay? But so we did discuss that, and to continue down the road, and then going north along your property, between your property and Mr. Potter's. We just did discuss that, but that doesn't solve the problem for Mr. Morley, okay? So we weighed that, and it was our determination at that time, based on the record, that expanded route width in that area, that particular to the west, was not going to give us a result that would be any different. So I hear what you're saying. That was considered. I think Mr. Potter and Mr. Martens would have been open to that, but our concern again was the fact that we're trying to avoid the homeowner on the I can't remember the name of the road there that goes north-south on the east end of this route. So we did talk about that. So
I wish that we had known about this and that we could have participated directly. I understand the attorney says that, I'm paraphrasing, you can't notify everybody of everything. Well, I think you should.
Oh.
And if 200 people
you do
show
you
up-
do. I assume you used some air conditioning this weekend. Okay, I'm assuming you used some air conditioning this weekend. Okay, to say that we should notify everything of everybody, we would never be able to provide you air conditioning. Okay, because we wouldn't be able. I know these are ugly facilities. I hate them too. I wish I could bury them. Okay, so that you don't have to look at them, and you could farm right over them. That would be bad for you because it would dig up the prairie to get it underground. But nonetheless, it's a tough call. It's not a fun decision. I can tell you that. We're not here trying to say we're ignoring you. We're trying to hear you. I'm going to ask a question. Okay, my staff will cringe when I ask it. Okay, and I'm willing to relook at a little bit of this, but expanded route width is a possibility. Okay, and the discussion. We had that discussion last time, and we kind of shot it down because of the potential homeowner. I don't know what's going on there. I was making a decision on assurances from Mr. Martens and Mr. Potter, but I'm open to looking at that expanded route width if there is a route there to go down the road and then north. Still not going to make Mr. Morley happy, but you know what I'm talking about, Mr. Welsh, to expand the route width so that it allows the line to go between Potter's property and Mrs. Jensen's property on a north-south line. Again, you got to get everybody to agree. And by the way, what I'm suggesting, and I said this at the last meeting, this is not like the chances of success are more like Tim Laudner's batting average than Joe Mauer's. Okay, and that's 1/10 of the time they happen. 1/3 of the time is really, really unbelievable. Okay, it doesn't happen every time when we expand route width. So I'm just trying to. That was a consideration we had, and we didn't have your input. So
I also, Commissioner Tuma, just want to point out that, like, originally the company did propose the route that Ms. Jensen is advocating that we reconsider and go back to. And so I think what we're seeing play out in real time is, these are difficult decisions that we make at the time, and we as the five of us don't always get it right. So
Or
I
have all the
appreciate-
all the information.
For all the information. So I do appreciate that you're pushing the company to now like go back another direction, but
But the chances of success, I know, Madam Chair, I agree.
but
with
you're
you.
not proposing we go back just to the blue route? Because why not?
Well, because as I sit here, look at it now, and now I haven't heard from Mr. Morley, but I see on the record what's there, and I read his comments. If I look at the whole record right now, where I sit today, okay, and if I had to make the decision now with the new information that I have, okay, not a lot of new, but it makes the decision harder, but I still would not change my decision because I want to avoid Mr. Potter's residence and the 3 other landowners well, actually 4 other landowners to the west, okay? But there was some discussion of expanding the route with here to have the conversation we're having right now. And I guess I was trying to explore that. That would only go up to Mr. Potter's eastern boundary and then head north to follow the alternative 213 that we did before. It runs right by the wildlife area and Mr. Morley's property. Again, I don't know what the chances of success are of such a route. And I do remember in the conversation that Mr. Potter was open to that concept, but we chose not to go down that route because of the potential impact to one landowner, which is the property right next to that, a very east end there. There's a little yellow dot when you see on the map there. That's we had concern about that, but nobody's had those conversations with those people. So I'm just curious what the applicant would say. I'm ready to deny, but I'm open to working with these landowners.
Ms. Agramonte?
Chair Sieben, Commissioner Tuma, first, I'm not quite sure I'm following exactly what you would want to be explored, and I share the.
Let me be clear first on that before you share what your other thoughts are. Okay, you're looking at the map right now. Okay.
Yes, sir.
Okay, and you see 2 B4s. Okay, you see
No,
the 2
I
B4s.
can't see that. I need my
Okay.
glasses or something.
Can you zoom in on the right side of the map, Scott?
Mr. Blodgett or someone else is controlling the map. Mary?
Okay, stop right there. Okay. Ms. Jensen, your property is the one with the light green little dotted area that, okay, with looks like a stream that runs through there, right? And your prairie is up there by the second from the right, 213, just to the left of that, correct?
Sorry, I'm not following.
Okay, look at the 213 on the map there. You
There's
see
a
the
lot of
213s?
213s.
Yep.
Which
The one on the
213?
right, okay, the right, and you go over to the second 213, and then right just to the left of that is your prairie, right?
Right. The light area that you see is the rim,
Yep.
and then the prairie is to the north of that.
Okay, and then if you go just a little bit more to the left, you see kind of a dark line, okay? That's a fence row, okay, of a bunch of tree fence rows, okay? That dark line are trees, right?
Right, that's fieldland brick, yes.
Yep. And so if you go down from there, it goes down to the B4 route on 310, okay? So if I go south, going down, okay? And there's a yellow dot there just to the right of the tree line, okay? I'm assuming that must have been an old residence or something because no one lives there anymore.
No, it's my machine shed.
Your machine shed. Yep.
I work there.
And so you see the 2 B4s if you go back to the right, okay? So what I'm saying is we had considered an alternative expanded route width going along that B4 route up into that dark line, which is the tree fence line. We'd wipe out all those trees, okay? And we would go north, and then it would follow 213 going west, okay? So it wouldn't cross your prairie. That was considered. We talked about it. We chose not to do it because of the impact on the residents, the potential residents, just to the right of that first B4, okay, on 310, okay? That was the decision we made. At least that's how I remember it, okay? Okay, so I'm saying to you, if we would expand the route width to allow the line to run along your tree line, okay, I thought I heard that's what you would have been open to. Okay, I'm trying to understand what you said to me, okay?
You have to speak into the microphone, Miss Jensen.
So, what I said was, there's a mile between the home site and my tree line. And it could turn south anywhere in that mile. And be further away from Mr. Potter's house.
Oh,
which
so
is
you're
like
saying,
west.
you're suggesting to me to do a whole nother route,
No,
okay, and go south and, well, that's where the line was going to be. It was going to be south of his property, so.
right, but you could, to the east of the property, take it south to 310th Street. And it would be,
I'm having a problem visualizing this. Is there, maybe Mr. Eck, is it possible for us to,
Move the hand.
move the hand so we can see?
So she's
down in the
suggesting
corner,
go by the dark line, the fence line that we're just talking about.
To the
that's
right.
So Mr. Potter's right there, yep.
and a workshop. From there to the east, to that dark line, which is the field wind break, is approximately a mile. You could turn south anywhere.
I don't understand when you say turn south. I mean,
Turn south to go down to 310.
it's on 310.
Oh, no, I'm saying, I'm sorry. So the proposed 213 going across, it could turn south east of the Potter household, going back down to 310.
Why?
Because
Takes
then
it
you
back
wouldn't
to the
affect
road.
all the other property owners that are newly affected by the 213 change.
Why wouldn't we just keep going down B4 then? Why wouldn't we go down the original route avoids your property? That's what I thought I heard you say.
Well, the
Why
original,
would I go north and come back down?
what I'm saying is keep 213 until
Let's
just east of the Potter property and go back down to 310.
maybe we're starting from the wrong direction. Let's do this. Let's start from the east and go west, okay? So I'm heading from the east. There's those windmills out there, and it goes by the windmills. It goes by Mr. Martin's property, okay? And then it crosses whatever that road is. I forgot the name of the road.
Kenwood Avenue.
Kenwood Avenue, okay? Crosses Kenwood Avenue, and now the route goes north, okay? And then crosses on 213 and goes across your property.
Wait, can you move you're not moving the thing the way Commissioner Tooma is talking about.
So that's Kenwood Avenue, and it goes north. So I think we're just starting from the different starting point, okay? And so right now, what I think you're telling me, okay, now go to the next map, okay? You want us to continue to go down from the east, heading west, to continue down down the B4 route, okay? And then you say at any time once you get into Mr. Potter's property, then you could go north and then west.
Right.
Okay, so we're just starting from a different direction. Okay. So, and that's what I was suggesting to you. One of the discussions we had at the hearing was starting from my direction, okay, we would go east and then head north at that tree line, okay, that fence line, that property line between you and Mr. Potter, okay? We decided to vote against that because of the residents down on the road there, just on the very far east end of this map, okay?
And is that 4 residences, Commissioner Tooma?
This is
Or
only
what?
one potential resident, okay? The other 4 residences.
Is that the abandoned house, or
That's
we're
the
not?
abandoned house, yep. and the other 4 residences are to the west.
Okay, Madam
And
Chair.
so what she's suggesting is we would avoid Mr. Potter and the 4 houses, okay, if we were to do that, okay? We chose not to do that because of the potential residents there.
Madam Chair.
Commissioner Partridge.
This is probably a highly unusual request, but I'm struggling with the different maps. Would it be possible for Commissioner Tuma to draw it on a piece of paper so that Mr. Eck can display it? I really am,
Let's
like,
just
I appreciate you, Ms. Jensen, and I think that prairie land is very important, and I just am struggling with the mapping. And we really want to make sure that we fully understand what you're proposing. So if we could take like 5 minutes to just make sure that we're all seeing the same picture, that would be really helpful.
It will take more than 5 minutes. I also
Okay.
want Mr. Eck to put the original proposed route by Xcel highlighted in a different color through this area that the commission chose not to adopt and instead chose route alternative 213. Because in my mind, that is the alternative that the commission should consider, whether we made a mistake in selecting route alternative 213, which we did after a lot of discussion, but with not all of the information contained, with Ms. Jensen's comments here today. So instead of now trying to draw up new maps entirely or new routes, that is not a good solution in my mind. It should be either back to what the proposal was before, or because everybody had notice of that, or alternative route 213, which we selected. Is that fair, Commissioner Tuma?
It is somewhat fair. I would point out we did have a consideration of an expanded route within this space. That was in front of us, and we did vote that down. So that is a fair reconsideration for us to do.
Right, I agree with that. And Ms. Agramonte, do you have any other things that you think we should have highlighted on the map that, before we break, that are unclear to you or that you want clarified?
Chair Sieben, I think the direction we're going now will be very helpful to have a map that we can all.
But anything else you need on the map?
Nothing else I need on the map, thank you.
Okay. We'll take a break for Mr. Eck. How much time do you need? 10 minutes or 15? Okay. The commission will come back from recess at 11:10 a.m. Thank you. The commission will come back from its recess. Mr. Eck, will you please put up the map that you drew? And Ms. Agramonte, please step us through what you see on the route or on this new map. What is the red line, the blue line, and the yellow line?
The red line is the approved route. The blue line was the blue route that was not accepted during the commission's April meeting.
You have to speak up a little bit.
The blue line was the route that was not accepted but was considered in the record. I understand the yellow line to be the line that Commissioner Tuma was describing to avoid bisecting the Jensen parcel.
And where is the blue route is what was originally proposed, and it connects right now on a different map to the remainder. Oh, there we go.
Yep, 213 was an alternative to the blue route.
So, Commissioner Tuma, the alternative 213 that the commission proposed,
Commission accepted is
the commission ordered in our order, is the red route now.
Yep.
And what you're suggesting is that we consider a new, you follow the line here from east to west, go up 213 on the red route as it shows, and then proceed west.
No, Madam Chair. What I understand, I'm not proposing this.
You have to speak up. 'Cause
I'm not
it's hard to
proposing
hear.
this, Madam Chair. What I'm trying to understand is what Ms. Jensen said and what I understand she said, okay, as a proposal is that we would continue from east to west on the blue route until the yellow line or thereafter somewhat, just slightly, I guess, before you get to Mr. Potter's house, which are those buildings on County Road 6, and go north. So the yellow line is to reflect what she suggested to us. And I was just pointing out before, in the original hearing, I had proposed this as an expanded route width, and we did not accept it, okay? And so we're not introducing new evidence here. This was all before us. We made a decision not to do the yellow line, essentially, okay? And Scott, if you scroll to go west, okay, and one of the reasons we did, okay, was there's the residents here that we were concerned about, the 3 residents on the far west end of Blue Route, okay? And we were also, and I'll go back to the middle, we were also concerned about the potential residents on the far east end. So go all the way to the east end of this map. There's a potential residence there. And so we made the decision in the hearing, okay, to go with the red route and the red route only and not expand the route to the west. We did expand it to the east, but that's not relevant for us today. It is whether we reconsider our decision not to expand the route width, okay, or not. Okay, that's what I think Ms. Jensen is suggesting, which what I would believe would be far different what Mr. Morley would want, and we should probably hear from him also. I don't need to get into discussion with Ms. Jensen, otherwise this is what you were suggesting, right, Ms. Jensen?
It's close. I'm suggesting
You
that,
need to speak into the microphone.
sorry. Close. I'm expecting, I'm describing, the yellow line.
We're probably not gonna put it right down in Mr. Potter's field. It's gonna either between you and Mr. Potter, or it's not going anywhere. So don't get too greedy, is all I'm saying.
No, I'm not being greedy, but this way puts it right through the middle of our field. So.
What does it? It
three-
puts it right down, it puts it right down between you and Mr. Potter.
No, the way it's now, right? You're saying that if.
I'm saying the yellow line. We're talking
Right.
about the yellow line.
Okay.
I'm trying to get your yellow line on the map here that you told me about,
Mm-hmm.
okay? So I'm looking at this yellow line, What you suggested me was this yellow line or somewhere from that yellow line over to Mr. Potter's house. That's
Right.
what you said,
Right.
okay?
Yes.
So yes, we're done?
That's what-
Commissioner Tuma, just
That's what I
let her
proposed.
speak. Ms.
But it-
Jensen,
I'm sorry?
go ahead, but we need to
Move it
slow
on.
down.
I know. You know, you had said that Mr. Morley wouldn't like that change, and I'll just mention that if we went from
Well, I
County
want to
Road
hear from
6.
Mr. Morley.
What's that?
I want to hear from Mr. Morley.
No, just let her finish.
Let me just-
Commissioner Tuma, Ms. Jensen, let me speak too, and
Okay. I'm
try to
sorry.
be a mediator between you two. And we're all getting a little frustrated because we're trying to draw a map on a line that's not working for all of us in the same way. So you need to be clear and responsive to Commissioner Tuma when he asked you, is the yellow line what you are proposing? And you think,
Exactly.
and then explain why it's not.
I'm proposing somewhere between the yellow line and the edge of the Potter's home, perhaps in the middle there. And I'll just note that both affect Mr. Morley, but as it stands, it affects 2 miles of Mr. Morley's property. If we go, say, a quarter of a mile east of Potter's, it will only affect a quarter of a mile of Morley's property. And it would not affect Matt Johnson, Cameron Liebel, Joel Saman, 3 other property owners.
So you would propose to shift the yellow line slightly to the west, but not all the way to that next, like where Mr. Eck has drawn the line?
Yeah, that would be a good spot.
And, okay,
Yeah, Madam Chair, this is something that should have been done during the whole process you were involved in. You could have proposed this route. Now, Mr. Potter's not here, okay? So, what
it's
we're
not going
doing-
on Mr.
Yeah,
Potter's land, though.
It is. That's right through his field.
That it.
Okay.
I think, okay, so Ms. Jensen, we have to go back to what I was trying to say before. And Commissioner Tuma just said, like, we are trying to either reconsider our decision for Route Alternative 213 or go back to the route that the applicant originally proposed, which is the blue route on the screen. Is that correct?
That is correct.
And Ms. Agramonte, provide some clarity here on what the company thinks is a way to make everybody happy and do this without having everybody who's now, Mr. Potter isn't here today, so.
Chair Sieben, Commissioners, setting aside what I think is an impossible goal, and I think that is something these routing matters present to you each and every time. What I'm hearing today is trade-offs. There's no perfect route through here, and that those who have been present at the hearing have very artfully and very sincerely advocated to minimize the impacts on their property, and that you are tasked with looking at the line overall and trying to balance it among multiple properties, multiple impacts, and the company believes the commission made the right choice at its April meeting. What would be introduced here is new negotiations with the landowners. I can advise that Mr. Potter's already granted a 20-acre easement across the north strip of his property. And based, at least on my experience with him in April, I wouldn't expect that he would be open to having the line where Ms. Jensen wants it. And that with these large projects, there is some sequence. There's land acquisition, there's pole ordering, there's design, and that I don't believe what's been presented to you is different than what was in the record to warrant disrupting that process or making a different decision.
And Madam Chair, I would like to hear from Mr. Morley.
Mr. Morley, if you're online and can hear us, can you please turn your camera on and then state your name for the record? If you can't turn your camera on, just go ahead. Mr. Morley, are you there?
Here.
State your name.
Hello? Thomas Morley, Redwood Falls, owner of property in section 17 and 18 of Redwood Falls Township. Did you get that?
We did. Go ahead.
Okay, perfect. I have a question for Mr. Tuma. Did you get the reconsideration letter from us on July 1 that we emailed to Scott Eck?
Yes, all of the commissioners have received it and have reviewed it. To my knowledge, I have, and they're all nodding their heads. We have received it and reviewed it.
Thank you. Okay, with that being said, the route that you just kind of thought you might go with the blue line and not the yellow line on Diane's, but over on Mr. Potter's, farther to the west, and then you'd go north. Well, our son is planning on building a house on number 6, less than a quarter mile. The property's already been taken out or never put in the program for him to build a house there. And I just don't like to see this line going there for that reason of him building his house. He's only 33. He's a young kid. He's got a good job. He farms with me. And if you read that letter, Mr. Tuma, the route that I kind of suggested on Kenwood and 310th, if you went back 1/2 mile there to the east, and then you went south 1/2 mile, and that was in section 21, then you could turn and go west all the way across 20 and 19. You wouldn't interfere with anybody's building site. And 2 of your people already you've contacted, the Samans. They own that property there. That would be in 21 and 20. And then Stephen J. Nelson, who's on the east edge of Highway 71 by the cemetery. That would be another piece of property you would go across. And then the other one is Richard Nelson. And that would not interfere with anybody, with Potters or Mertens or nobody. It's just a suggestion. I don't mind that line. I do. The line on Potters, that's the darker yellow going north off of 310th, that would come back on our property, and it would still be by my son's house, okay? That's what I'm trying to get away from.
Mr. Potter, Mr. Morley, the choice before the commission now is either to reconsider our original decision, which was to go with Route 213, or to go back to reconsider, and then if we reconsider, then we could maybe look at the yellow alternatives. From my review of the record right now and where we're at, I think the best thing we can do as a commission is go with the original decision we made and, continue to drill in with Xcel as much as we can over the protection of the prairie land. Otherwise, what I'm afraid will happen is we're going to be tying ourselves in knots here over where to put that yellow line, what it means for the other side, and how to move forward. And I think you hit the nail on the head when you said, you recognize that we're not going to make everybody happy. I agree with that, but I think that in the interest of moving forward, we appreciate you coming on and offering these suggestions, but I'm just going to try to move us along
Madam
and
Chair,
get
I'm ready
Commissioner.
for a motion if you're
Will you
ready.
just let me talk?
Oh, no, I'm sorry. I thought you were asking for a motion.
I'm trying to say that.
I would just like to make one more comment, please.
Have at it.
with this being said, I really would not like it to go across my property if all possible. I don't think it would be that big of a change because I don't think they've done borings yet because I've monitored this. I think they have on Mr. Potter's. I just, if I would have gotten notification from the beginning about all this and the commissioners there have read my letter that we submitted a email on July 1, I would have been at these meetings.
Yeah.
I would have honestly been at these meetings. No notifications, as that's what's throwing this into a chaos for us.
I understand. Ms. Agramonte, will you please respond to Mr. Morley's concerns about his individual property and what's happening moving forward if we stick with the decision the commission already made?
Chair Steven, just one moment, please. Chair Steven, Commissioners, my understanding is the alignment would be on the property line, avoiding his protected areas. And my remote team is advising that Mr. Morley was on the notification lists. I don't have the specific ones. The EIS scoping meetings and hearings. Mr. Morley was one of the landowners on the notification.
Just to that, Madam Chair, if I could.
Yes.
My understanding is that a line, alignment was south of Morley's property in that area where he has his easement. So it's on the property line past the conservation easements, okay?
A little
and then Mr.
louder.
Porter agreed to that, and I remember this discussion that he was willing to put the towers on his property south of the protected land. And
You have to speak up. We can't hear you.
Chair
Yeah,
Steven.
I can't hear you.
I'll say that again. It is my understanding, and I remember this conversation, and she'll say yes. I'm only putting it on for the record, for you, okay? For the record, the line actually drops, the alignment drops south of your property where you have your conservation easements, and then it re-enters and it's on the property line after the conservation easements to County Road 6. Is that your understanding, Mrs. Agramonte?
Chair Steven, Commissioner Tuma, thank you for that clarifying question. Yes.
And you can still have conversations with a modification at landowner request with Mr. Potter to put the poles in all of Mr. Potter's field if you can. But right now, the alignment, I think, is appropriate, following our factors in this place to be on the property line between two agricultural fields. Is that your understanding, Ms. Agramonte?
Chair Steven, Commissioner Tuma, yes.
And so, Mr. Morley, you should have conversations with Xcel about that, but the alignment right now, I think, is appropriately between two ag fields. I understand your son's potential home. There are other potential homes here too. So, Madam Chair, my belief is, and it hasn't changed, okay, this is a tough decision, okay? It's a hard one. We struggled with it when we originally made it. People struggled with it in putting together options here. This has been talked about and dealt with, I think, thoroughly. Even though it's a close call, it still comes down to me between impacting 5 landowners versus a potential impact of 1 landowner, homeowners. And I think the human impact from the homeowners, in my mind, back then trumped, okay? And it was a close call. I definitely know that. And I expect Xcel to continue to work with landowners to find a least impactful, less unhappy route through here, okay? And that's their commitment to admit it several times already. So that's, I'm ready to move decision option 10 with a slight modification to add in the Morley's name into that number 10.
And then Commissioner Tuma or staff, do we need anything written in our reconsideration assessment about the Xcel commitment that we are all going to hear about and want to hear about if they can't protect Miss Jensen's prairie? Do we need any additional language in the recon order related to their commitment around the native prairie land.
Chair Sieben, I think the permit provides a fairly extensive section on prairie and on how.
Yeah, but this is specific to this one parcel that I think we had additional requirements for engagement. So Ms. Agramonte, will you commit to filing a compliance filing on how that in this docket, just verbally file a compliance filing indicating how you work with Ms. Jensen to minimize the impact to this particular parcel that we discussed today, and perhaps that could be a follow-up instead of adding something to the reconsideration order?
Chair Sieben, yes. We'll provide an update in either a regular filing or a separate filing indicating how the prairie was preserved during construction.
And your continued dialogue with Ms. Jensen and her sisters on that mitigation too? That works? I mean, you'll document in a compliance filing how you're working with them. So maybe, 3 months after the reconsideration, you'll file a compliance filing on how the discussions are going or what has taken place. And then again, subsequent to the pre-construction or something like that.
At plan and profile, they will. So I think she's asking you to file something before plan and profile.
Chair Sieben, Commissioner Tuma, I understand, yes, we'll give an update about the discussions with Ms. Jensen and her sisters, and then also the plan to avoid the prairie.
Okay, thank you. Commissioner Tuma, what's your motion again
Motion is number 10, and modifying it by also putting in the Morley's name in there.
Commissioner Tuma denies the request for reconsideration by Diane Jensen, Linda Nesberg, Norma Schlemmer, and Matt Morley. Is there any discussion of his motion? All commissioners in favor, please say aye. Aye. Opposed? The motion prevails. Commissioner Tuma.
Madam Chair, next I would like to talk about the Platsons, if we could.
That's either decision option 8 or 9, commissioners.
9, yes, and that was also an 8A that was pre-filed by me. And so let's just start, Ms. Agramonte, with 8A. Okay, this is not a modification of the permit. It's just a decision on our own motion here.
Can you speak up?
Yes. It's our decision on our own to do a vegetation management plan with this particular landowner for their tree farm. This came up in the Wabasha siting route where there was a tree farm, and Darylyn was willing to agree to do a specific management plan for them. I know, as a matter of fact, I know this is not going to make the Platsons happy. They want to move the line. I get that. Okay. But I think for consistency's sake and for our obligation under the statute where we're supposed to reduce human conflict, not succeeding so far, but we're trying our best. Okay. It would make sense to have a plan with the tree farm underneath power line so that we know when Xcel can come in there and cut trees down that are getting too high and what the expectation of the landowner as far as height of tree farms. My assumption, and this is where I want to be careful, I made some assumptions on this particular area when we went into our hearing in April, and I want to alleviate that. My assumption was that they could continue to operate their tree farm under the line, and so I want to confirm that, and then I want to make sure that we do develop a plan with them in particular so that we reduce conflict. So that's the first question. I have another assumption I want to run down later, but I want to make sure we're okay with decision option 8A.
Ms. Agramonte.
Thank you, Chair Sieben, Commissioner Tuma. Xcel Energy reviewed your proposed new decision option, and given the magnitude of this line and the actual circumstances on the ground, cannot support it. There are maybe 7 to 8 trees currently in the right-of-way. I understand the Pladsons have talked about re-upping their tree farm. But there's going to be 2,000 megawatts hanging on this line, and it is inconsistent with the vegetation management practices of the company to allow these trees because they can grow tall enough to interfere with the line. So I've checked with our vegetation management team and the company, and for this, we think it is more appropriate, as stated in then Ira's comments, that we've moved the line, the poles as much as possible to minimize the area impacted, and that they can be compensated if it's a commercial crop.
Well, Madam Chair, I guess I'm a little shocked because
Can you speak up?
I'm a little shocked. Okay, I'll speak up. I was trying to. Yeah, we don't want them to grow to a height that's not appropriate, but I can't imagine 6 feet is going to cause, to 10 feet is going to cause an outage. Okay, they can, if they're managed, just like anything else below it is managed. Heck, I got corn crops in my area that grow 10 feet high. Okay, so we're not saying that they can. That's the expected management plan. Okay, and I guess I'm just a little surprised that Dairyland is okay with doing it, but Xcel is not. I mean, this is I think this is inconsistent, and we want to be consistent in the commission. So, help me out here. I'm not feeling comfortable busting my butt here for you, but come on.
Chair, Commissioner, right now we have a property that actually isn't actively managed as a tree farm, so I think it's distinct from the circumstances that Commissioner Tuma described. And individual management plans for individual properties is an added risk in maintaining the system. Yes, it's done. I'm not going to disagree that Dairyland has identified a way to do it, but I don't know, or we don't know who might own the property in the future, and the compatibility of trees within the right-of-way is determined on what they can grow, not what we would expect them to be harvested if they were Christmas trees.
So your folks don't go out, check the line? They don't go check lines? I mean, I thought they check lines on a regular basis. That's my expectation. They do check lines regular basis, and if a tree grows over it, what do? You cut it down. That's what you do now. What's so different with working with this landowner if he wants to do a tree farm?
Chair Sieben, Commissioner Tuma, that could be said for any property owner who wants to keep their trees, that the company could come through on the next vegetation management cycle and cut them down. For uniform management of the right-of-way, this is an incompatible species. So I'm telling you the company's preference. I understand your dissatisfaction with that preference, but that's the company believes is the safest and most reliable way to maintain this line is to not have incompatible species.
And then what is happening for that parcel, and Commissioner Tuma probably knows that then, if they can't grow the trees within the right-of-way, what happens to the entirety of their business, the Christmas tree farm? Are you buying them out then as a result, or what's the practical implication?
Chair Sieben, Commissioners, I don't know what the current negotiation status is with the Platzens. I understand that we don't have right-of-way yet because of this issue, but they do still have area to grow their Christmas trees. This is a small edge. As I mentioned, the line has been moved.
Like how many square feet are we talking?
One moment, please.
It's a small piece, it sounds like.
Well, you'll see in a second here, but
Okay.
Go ahead and answer your questions.
It's a 2.2 acre area.
.2 acres out of a total of what?
And Madam Chair, if I can add a question, are you saying they can't grow any trees on a 2.2 acre area or just within the smaller right-of-way?
While we're waiting, if you're here for item number 4, we're not going to now get to that item till at least 1 o'clock. So if you want to go get lunch or something else, you're welcome to do so, because I'm going to need a lunch break after we finish this item. So hopefully that helps some of you who are in the room. Or you can stay for the fun.
Or you can stay for the fun, huh?
Yeah. Sorry about the delay for.
Apologize, we're doing those calculations now.
You might as well just get that first map up.
Yeah. Chair Sieben, Commissioners, by our calculation, looking at an aerial map, they have a 9.3 acre area where they could grow trees, which again, they have not been.
You're
they're a
saying
commercial
under
operation.
the commission's decision and what's consistent with the vegetation management plan practices that you will follow on this permit, you don't want them growing trees only within the right-of-way, which constitutes 2 point something acres.
Chair Sieben, yes.
And Commissioner Tuma and Mr. Blodgett have the map of the parcel. And Commissioner Tuma, walk us through why you think that is a good or not good response.
Jay, where's the map that we?
A little louder, we can't hear.
I'm actually staff a question.
Mr. Eck might have the map.
Chair Sieben, Commissioners, while we're looking, also vegetation management has advised me that fires are also a concern under the line, and that by not having vegetation, you have that break.
You have that all the time, but that's neither here nor there.
Commissioner Tuma, you have to speak up.
I know.
I'm like
right
deaf
now in
today
the map
because of the fan or
you
something.
have, if you
but
could just zoom in. No, just stay right there. I'm still a little set off by the fact that they're not agreeing to a vegetation management plan, but just so that we can zoom in and you understand the decision that we made on this. And one of the things that was nagging me on reconsideration is that the original blue route, as you see, is the original blue route would have gone through some mature forest. The reason they did that was if they would have went down, continued to go down, that's County Road 142, they would have crossed probably in the front yard of the Platsons, and they would have crossed over 1, 2, 3, 4, 5, 6 other residents that would have been impacted if they continued to go down 142. So the company made the right decision, okay, and suggested that the blue route go off of 142. In the process, it was determined that there would be too many mature trees cut down, and that's the decision we agreed with. And then alternative 244 was proposed. I don't know if it was a DNR proposal or a landowner proposal, but that blue line would have gone through several parcels of land and cut down mature trees. And so we made the decision to go along an active farm fields and cross over the back part of the Platson property. Where I have tree farm noted, okay, is, I think, exactly what Ms. Agramonte was trying to point out. It's not all of that property, and I was only going by descriptions. There's no survey that I could find in the record of the tree farm locations or how many trees were there. I was just going by the description Mr. Platson provided us in about being in his back field, okay? So that's what's circled there, a back field outside of his mature trees where apparently he has Christmas trees for people to cut down. Doesn't sound like it's an active farm at this stage, but he's considering it being an active farm. So if you could go to the next map. And here's what was nagging me about the recon. I understand that you're working with Mr. Platson, and those were the yellow lines that you provided us, okay? The wording on here with the tree farm again and the active irrigated field, those are things that we're just picking up from the map. They're my markings, okay? They're not a surveyed marking. And so I was trying to understand what was going on here, okay? And so what I'm understanding from our original route, which we could reconsider, okay, but I'm suggesting not, okay, was that I assumed that you were going to do pole placement 1, okay, based on the blue route. I'm not talking about what you're doing there. I want you to do that, okay, based on the fact there's a turn there, okay. My assumption is that was kind of where you're thinking there was going to be a pole, okay. And that pole 2, okay, Mr. Walsh, was kind of about what you're thinking where pole 2 would be, because there's a turn there, unless you figured out some magical way to turn lines in space, okay. Here's the assumption I made, okay, and which would lead me possibly to reconsideration, okay, was that I was hoping that he could still farm his trees under there, but my assumption was that going another 1,000-foot span, you were going to put a pole on his property where it says pole 3 ? And that there would be a pole 4. Now I suppose you could have an extra longer area here, or you could have possibly put the pole in the middle of the field, which would have bothered me, and I would have made some changes to our order if I knew that was the case. Now that I look at that, upon re-examining this, I just wanted to know if we were to follow the original route, which is a possibility, okay? If you can't get the neighbors to agree and the Janskys don't want to have interference with their active irrigation field, it's going to follow the existing route. And I just want some assurances, okay, that you're going to minimize the impact on their farm, and I'll ask them things about the tree farm in a second. But pole placement, I know it drives you crazy, Ms. Agramonte, but this is one that would have caused me to make a different decision. So tell me, is that your plan, was that to put the pole 3 generally in that area? And I'm not saying you have to give me exact location, but it would have put it on his property and avoid having a pole in the middle of his field.
Chair Stephen, Commissioner Tuma, what I understand on the blue route is there would be a pole in the middle of the Platson field because the span is too long. The way it's been redesigned, it will be on the edge of his property where you can see in our filing the yellow line and then that turn.
My question.
I don't understand where you're saying, on the edge of, near where pole 2 is, or north of there?
I'm sorry, there's the poles are numbered by the blue line, by the original route, and we're following the yellow route now. And so the plan is to put that pole at the southeast edge of the Platson property.
And I don't care about what you're negotiating with him. I want to know what we did so that I don't need to modify my order, because it could end up being on the blue line. I don't care about the yellow lines. And I am not understanding why you would need a pole in the middle of his field with a 1,000-foot span.
Chair Stephen, Commissioner Tuma, I'm sorry, I have the project manager trying to revisit the pole placement on the original route to answer your question.
Chair Stephen, I have a question for Commissioner Tuma. Can you clarify? So,
Just a second.
Okay.
Let them catch up so they don't miss what we're asking.
Chair Stephen, Commissioner Tuma, I thought it'd be better to bring Mr. Samuel up to answer the question.
State your name loudly for the record, please.
Good afternoon, Joe Samuel with Xcel Energy.
Mr. Samuel, answer Commissioner Tuma's question.
So the question that Commissioner Tuma has is if we look at a structure placement at pole 4 and then pole 2 on the blue route, there would be a pole that would be positioned at roughly the T in the word tree farm. So we have 1,000-foot spacing in general between our transmission structures.
My question to you, having driven under Hampton Line, okay, multiple times, okay, why can't the pole placement be where pole number 3 is? That's the 1,000 foot. If you go 1,000 foot from pole 2, okay, you could move off of his property and be on the property line still, but it may not matter if we're not going to allow him to have trees. I'm just trying to understand this because
Sure.
I was making some assumptions.
Yeah, and
in
I would.
April.
You have to wait for me to call on you. Mr. Samuel.
Thank you. Chair, Commissioner Tuma, I would say that from our structure spotting, we held structure or pole 4 on your map versus pole 2. So if you measure 1,000 feet from pole 4, that gets you to roughly the T on the tree farm reference.
Why couldn't
Commissioner Tuma,
Thank you, Madam Chair.
and speak up, please.
Why couldn't you do 1,000 feet from pole 2? Because this is the part that I think I missed back when we first considered this. Not that we're going to reconsider it. I just missed it and didn't understand. I want to understand the facts. So why couldn't you do a pole 1,000 feet from pole 2?
Mr. Samuel.
Thank you, Chair. Commissioner Tuma, when we look at pole placement, just moving one structure one way or the other isn't an efficient design. So we actually have to look at how we carry that 1,000-foot spacing as it spans out through a section of line. So impacting, if we were to start at pole 2, go 1,000 feet to pole 3, somewhere along that alignment from pole 4 to the south, we'd have to adjust our structures. And being that that's in a deflection point or an angled structure, there are some limitations that if we were to move that further south into the east, we would have more impacts to that irrigated field.
My last
Commissioner Tuma.
question, Madam Chair, on this is my understanding if we were to have to go with the blue route, if that's what comes out of this, because that's what we're reconning today, you got to continue to work with this landowner and the neighboring landowners. I expect that. I was going to praise you for it, but now I'm a little ticked off that you won't let them grow us trees under there, but that's neither here nor there. But your understanding is where you see that tree farm, there's going to be 150 feet, 75 feet on each side of that blue line, if that's where we end up, right? And he would be able to grow his trees to the south and to the east, but not under your facility. That's what you're telling us is the alignment that we approved back in April.
Mr. Samuel.
Chair, Commissioner Tuma, that is correct. It would be 150-foot easement, 75 feet each side of the blue line. The trees could be grown outside of that 150-foot easement.
Madam
Commissioner
Chair,
Tuma.
this is another tough one. I apologize to Mr. Platson. I should have asked these questions back in April. I have examined it and am thinking about it. When I think about our decision for our original route and the fact that Xcel also avoided putting poles in the front yard of Mr. Platson, because I'm assuming, Mr. Samuelson, that's probably originally you had considered going down 142, did you not?
Mr. Samuel.
Thank you, Chair. Commissioner Tuma, Xcel is committed to following the alignment per the order.
I understand that, but when I look at this map, go back one map. I think, why is this so difficult? Can you go back one map? It shouldn't be that difficult of an answer for you, okay? Okay. There's 142, okay? That's the road there, okay? The logical thing using our factors, okay? We would have put a line all the way down 142 because it is an existing right-of-way.
Where's 142 on here?
That's the road that those yellow dots are on, okay? And you chose to give us a blue route that cut through mature trees. Right decision, because the first decision, the first option you had was to follow the right-of-way. But you did the right thing here, confirm that you did the right thing by not putting the power line in the front yard of Mr. Paulson and across the road from all the other property owners. That's the choice you made when you gave us the blue line, right?
Mr. Samuel.
Chair, Commissioner, that is correct. The blue line represented on this map is what was part of our route permit application.
You're making it hard for me to try to compliment Madam Chair. All I'm saying is the original decision that we made to follow this route, okay, given all of the considerations and all the problems that the blue line would have resulted in, and all the problems that would have resulted if we would have followed the right-of-way, okay, this was the best route through this spot, okay? The balance I have to have is, given that Mr. Patson's going to lose a couple acres of tree farm, okay? And so when I look at that, Madam Chair, and this is how I viewed it and consider it, you guys can correct me if I'm wrong, I think decision option 8 is the right thing. I'm disappointed that 8A is not something they would consider. I'd hope they would, but I'm not going to offer it for safety reasons and just offer decision option 8, which is deny the request for reconsideration, and anticipate that you are going to continue to work with the Platsons and the Janskys to find a nice, safe, careful route through here that meets their concerns. But I'm not holding out a whole lot of hope because of the fact that we got irrigation and stuff there. Okay, so I understand it completely. We made the right decision. I see no reason to go back on it, even if they don't allow them to have a tree farm, which is disappointing to me.
Commissioner Partridge.
Thank you, Chair Steven. I think staff has answered my question about the blue line versus the yellow line. I appreciate, Commissioner Tuma, your concern. I think looking at the yellow line, and it does appear that the company is working to try to negotiate the needs of these landowners. It's quite tricky, as with any line. And so I hope they'll continue to do that work and move those poles to where the irrigation is not affected and the impact on the tree farm is minimized to the extent possible.
Thank you, Commissioner Partridge. I didn't ask earlier, are the Pladsons here and wanted to provide comment? They're not here or online. Just checking, Mr. Eck.
Chair Sieben, they were unable to make it, and they're in a location that doesn't have internet or
Okay,
access.
thank you. Any other discussion on Commissioner Tuma's motion to deny the Pladsons' request for reconsideration? Hearing none, all in favor, please say aye. Aye. Opposed? The motion prevails. Is there a problem with the camera? Or it's not on? I don't know. Maybe it's good no one can see us
It's good it's
now.
not on.
Yeah. Is there any other motion
Yes,
in
one
here?
last motion, Madam Chair.
Ms. Brazil,
Brazil's
does it,
2 or 3 or 3A. Madam Chair, based on, I'm not going to make any assumptions now, okay?
just a second. Commissioner, there we go. Ms. Brazil Johnson had her hand up earlier, and so
could turn the
she's
camera on.
online. You can turn your camera on and state your name for the record if you're still with us. Ms. Brazil Johnson, welcome. Please state your name, and we'll wait to ask you any questions we have. But please go ahead and state your name.
Hi, my name is Ann Brazel Johnson, and I own land in Renville County.
Okay, great.
That's
Thank you.
impacted by the line.
Right, thanks for being on, and apologies for mispronouncing your name. Commissioner Tuma.
And actually, help us out. How do you like to be referred to? We've had Miss Johnson, Miss Brazil, we've had Brazil Johnson. How do you prefer to be referred to? So I apologize for that.
You can go by Ann Brazel.
Ann Brazel, okay. That's very helpful. Thank you.
Thank you.
Ms. Agramonte, thank you for your filing that you made yesterday, I believe it was. And my understanding, and I want to make sure we have this understanding, we will have a later docket that there is a commitment that you're working with the Birch Coulee folks, and that for now, minus some very unforeseen circumstance, okay, that the line is going to go on the property line between Miss Basil and the property that is now leased or controlled by Birch Coulee on the north-south and below the 115 kV line on the south. Is that what you are designing and understand is going to be the process?
Ms. Agramonte.
Chair Sieben, Commissioner Tuma, yes, the company has continued to work with Birch Coulee and with Birch Coulee's determination that it could redesign its facilities. Xcel Energy is intending to build the project as you described on the property line north-south and south of the 115 east-west adjacent to Ms. Brazel's property.
And I'm going to start out and kind of shake off what we just talked about. And I do want to thank you in particular for your hard work and trying to, I got to believe this was a lot of client management work and trying to figure out what to do right. And so I appreciate the hard work you and Ms. Waller-Pitts had to put into this. So I really do appreciate it. It saves everybody more time having to listen to us fight about what alignments mean and what route widths mean. And so here's my promise to you. Someday when you don't have any ex parte concerns and I am no longer here, I'm going to buy you a beer and we're going to go to a pub of your choosing. And anybody wants to come and listen to us argue about what's an alignment and where poles can be placed, they can come and join us.
I don't want to come.
I kind of figured that. So thank you. I appreciate that. Ms. Basil, okay?
Brazel.
Basil, how do I say it again? Brazel.
It's Brazel. Brazel, like dazzle.
Brazel like dazzle. Okay, let's see if we can land this plane here for you. Okay, I want you to completely understand what has transpired in the last week. Okay.
Okay.
So you've made a request to us, which you didn't know whether it was a recon or what you were doing. You're just frustrated. Somebody was putting flags out in your field where they weren't supposed to put them. Okay. And since you sent me that email, I've got it to the right people, and we have put together decisions and discussions internally in us, but we don't talk to the utility. We can't talk to them. Okay. That's a process called ex parte. We can't do that. Okay. And what we did in the process by raising your issue as a reconsideration, it allowed for Birch Coulee and Xcel to talk to each other, and they realized the appropriate course forward was for them to commit to doing a redesign of Birch Coulee, okay, so that it keeps it on the property line. So the poles will be half in your field and half in your neighbor's field, which right now, frankly, is just an agricultural field. Birch Coulee is not a facility because they're not there. And we've had several facilities that have come to us for permits that never would have happened. I kind of agreed with you. If it was a solar facility, it probably should all be in their property, but it's not. And there's going to be there in perpetuity, and we know what's going to happen. And so we would hate to put it all in your neighbor's field and then find out that there's no solar facility that's going to go there. And we have these factors in our statute and our rules that says, don't put it in ag fields if we can avoid it, and put it on property lines if we can do that. And I think you understood that, and I appreciated your understanding, because I think your last comments were to us, put it on the property line. That will work for us. And so that's what Xcel and Birch Coulee are committing to. Stay on for the second docket. Okay, stay on for the matinee, because we want to make sure they give us the same commitment on the record. Okay? So just so you understand, that's the way. There could be an unforeseen circumstance. We don't know what those are because they're unforeseen. So in other words, there's, a sinkhole right in the middle of your neighbor's field that goes right up to your boundary line and goes for 1,000 feet, okay? Then they may have to move it over to your property. But I'm going to get a commitment from Ms. Agramonte and this team that's up here right now that if there is any absolutely unforeseen thing that happens here, before you go out, start putting flags in her field, you are going to go and be very transparent with Miss Brazel, okay? Dazzle Brazel, okay? And you're going to get her name right, not unlike me, okay? And you're going to communicate with her well in advance if there is some sort of thing that comes up that was truly unanticipated. Is that the commitment that I have from the company? I'd like to hear from the company.
Before we get too much further, Commissioner Tuma, you said you got an email and shared it with the company. I just want to put on the record that that was filed. It was filed publicly,
everything is filed,
and so everything is above board with regard to the ex parte communication that took place.
And I didn't say I gave it to the company. I gave it to the right people, which is
Okay, I
Scott
think you
Eck.
said it a little differently than my ear heard. So I'm just putting on the record, Ms. Overland, because I saw you freak out about this, that it was e-filed and everybody knew about it, including all of the commissioners and our staff. So
That is correct.
go. Who are you asking, Ms. Agramonte?
I'm asking the company that they're going to make sure that they're very transparent if there's anything else that comes up that would cause it to interfere with Miss Brazel's property.
Mr.
Samuel.
Samuel.
Chair, Commissioners, yes, Xcel Energy is committed to working with Ms. Brazel on the routing of the transmission line on the property line. And we will notify her of any impacts where that may change in the future.
Thank you very much. You understand that, Miss Brazel?
I do. I appreciate your time and effort in coming to this conclusion. Well, hopefully it's a conclusion.
I think it is, Miss Brazel. And I want to, just a couple things. First of all, I want to apologize to the bottom of my heart, okay? Yes, you did send me an email, okay? And it was recommended by Mr. Greenslit that you send it to me. That was very, I view that as one of the greatest honors that I've had in this job, that he would have that confidence in me. I apologize. I was actually in the Boundary Waters when you sent it, so I wasn't ignoring you. When I got back from the Boundary Waters, I did send it to the right guy, Mr. Eck. And so if you don't have Mr. Eck's contact information, please email him again and make sure you are connected, okay? He will take care of you. You have one of our best public servants working on this, and he will take good care of you. If you see anything that causes you concern, okay, please email him immediately, okay? I want to apologize for the full industry as a whole. I don't know if Xcel or Birch Coulee will ever apologize to you, but the way they handled this was wrong as far as I'm concerned. This one commissioner was wrong. You should not have been, even if half of what you told me was accurate, which I believe 100% of it is unacceptable for this to happen, okay? And I want to apologize for all of us for that. That's not the way we expect our permittees, okay, applicants, or utilities to behave, okay? It was just simply wrong, okay? And I even double-checked it with my wife to make sure I was tracking, and she agreed with me. It was wrong, okay? So my apologies. And the last thing I want to tell you is, and this is from a crusty old politician who represented a rural district, okay? I have uncles, and all my uncles farmed on my dad's side, okay? I was, for whatever reason, my Uncle Bob had me down every time they were castrating the pigs, and I had to do that, okay? I've had all the terrible jobs you can think of, hay baling and all that. And if you grew up on a farm, and I saw that that was very valuable to you, what your father passed on to you, and you wanted to protect it. So Here's my request of you. Every time you look out east of your field, and I've seen your field, I drove by it 100 times in my lifetime because my wife lived out in South Dakota, so we drove up County Road 5 out of Franklin every time. And so I've seen it evolve from a farm to now it's fields, but it's still yours and it's still a value. And your father passed it on, and that was valuable to you. And so when you look at those ugly brown poles, just remember this. I think your dad's proud of you. That's all I have to say, Madam Chair. I would move decision option 3A.
Is there any other discussion of Commissioner Tuma's motion or questions? And that motion's clear, Mr. Blodgett. All those in favor, please say aye.
Aye.
Opposed? The motion prevails. Great. Now we are moving on to Birch Coulee. So, Ms. Brazel, if you want to stay on, you're certainly welcome to. Commissioners and staff, hopefully we can, a lot of this has been taken care of, so it won't take too much time, and then we will take a lunch break after this docket. Sound good? Mr. Janisic, please introduce agenda item number 2.
Good afternoon, Chair Stephen and Commissioners. On the matter of the application of Birch Coulee Solar for a site permit for the up to 125 megawatt Birch Coulee Solar project in Renville County, Minnesota. The questions before the Commission are, should the Commission adopt the Administrative Law Judge's findings of fact, conclusions of law, and recommendations? Should the Commission find that the environmental assessment and the record created at the public hearing adequately address the issues identified in the scoping decision? Should the Commission issue a site permit for the up to 125 megawatt Birch Coulee solar project? Commissioner Tuma filed some decision options that I have copies of if you'd like them, and staff did place them in the back of the room for those attending. That's all I have. Thank you.
Thank you, Mr. Janisic. It was my intention to not have opening comments, but why don't we move first to the applicant and give us your comments on the Tuma decision options that were filed later and your thoughts on those, and then we'll hear from parties either just briefly generally on the overall direction you'd like the commission to move here today on this. And
Thank you.
State your name for the record.
Thank you, Chair Sieben, Haley Waller-Pitts, Frederickson, and Byron on behalf of Birch Coulee Solar. And I can address the decision options, but if I may have the project representatives with me introduce themselves as well.
Good afternoon. I'm Lauren Caldwell. I'm a permitting project manager with AES.
Frank Rosell, AES, Director of Development for MISO.
Welcome. And the other parties, if you wanted to introduce yourself since we're on that roll.
Lauren Agnew, Environmental Review Manager with the Public Utilities Commission.
Richard Kajewski, Director of Government Affairs for the North Central States Regional Council of Carpenters, and I'll also be speaking on behalf of IUOE Local 49 today.
Kevin Pranis on behalf of Lyon, Minnesota, North Dakota.
Ms. Waller-Pitts.
Thank you, Chair Sieben. We have reviewed the new and revised decision options and suggested motion that was filed yesterday in this docket, and the company doesn't have any objection to the decision options and the motion as proposed. We appreciate that it reflects the additional comments that the company filed earlier this week.
Commissioner Tuma, did you have questions about that, or should we hear from the other parties?
Only just adjustment. on the second page of the motion, it said 69 kV line. We've been informed actually it's the 115 kV line. So 69 we would change to 115. And that's
And where?
Decision option 5N.
Mr. Kajewski, did you want to provide comments?
Thank you, Madam Chair and Commissioners. On behalf of the Carpenters and Local 49, we strongly support granting a site permit for Birch Coulee 125 megawatt solar project in Renville County. We urge the Minnesota PUC to adopt the findings of fact, conclusions, and of law, the recommendation issued by the administrative law judge, and to issue the site permit required for the timely advancement of this project. Birch Coulee Solar Project represents a critical investment in Minnesota's clean energy, in the future here in Minnesota of clean energy. The findings of fact clearly document the extensive and transparent review process led by the OAH and the Commission, including the extensive public record and comment period. Responsive filings were addressed by the applicant, and agencies addressed all substantive issues. Union carpenters and operators know firsthand that modern utility scale solar requires skilled labor. Birch Coulee, in their application and from our conversations, intends to hire local union workers requiring good middle-class salaries in accordance with collective bargaining agreements and apprenticeship programs. This project in southwestern Minnesota brings a lot of benefits, including 300 jobs, $18 million in tax revenue, electricity to 26,000 homes, and advances the state's goal for renewable energy. This collaborative approach in working with local landowners and stakeholders reflects its dedication to building sustainable long-term partnerships, and we thank the Commission for its careful review and urge adoption of the ALJ's recommendations in recognition of a record that fully and fairly addresses the issues identified in the scoping decision, and request that you issue a site permit for the project. Thank you.
Thank you. Mr. Pranis.
Chair Steven, Commissioners, agree with everything that Mr. Kajewski said. Obviously, we're in a challenging moment in terms of changes in federal policy that potentially jeopardize access to tax credits that make these projects feasible, and also ensure that the energy coming from them is affordable. And so we'll, appreciate in this, I think everyone's trying to move as quickly as they can, given challenges with interconnections, challenges with, acquiring components, trying to figure out how to comply with, all the new surprises coming out of Washington, D.C. And so I think the Commission can be helpful by approving this project, and that's not the end of the story, but at least that allows them to try to address the other issues and hopefully be able to get this built and claim whatever tax credits are available before they expire.
And Ms. Agnew, thank you for your work at EERA and now at the Commission. Anything you wanted to add?
Thank you, Chair Steven. At EERA and as the Commission, we find the revised decision options agreeable.
Okay, great. Questions from Commissioners? Commissioner Hahn.
Thank you, Chair Steven, for the applicant. Is it your first project in Minnesota?
Chair, Commissioner.
I forgot your name. Sorry, go ahead.
Frank Rosell. Yes, it will be our first project.
Okay, thank you. Welcome to Minnesota. I think this is a great place to build out this renewable generation. One thing I just want to give you a reminder, I think all the developers and utility building out infrastructure in Minnesota, they treat their landowners as a community member. You are being a community member. That means that's what Commissioner Tuma mentioned in prior docket. We had some concern that what went on in this issue. Without being a community member and just showing up as an outsider, that'll make a lot of our landowner unhappy, and we have an issue with it. I hope in the future you should play as a community member rather than developer trying to build a infrastructure. Yes, I understand you had an easement or you buy the land for your own facility. However, we have to consider a lot more than that. And also, rural community is not necessarily unique, and there are a lot of diversity. Sometimes the property tax is not everything to a lot of farmers. So we have to respect that choice.
And, did you have a response you wanted to reply? No. Ms. Waller-Pitts is shaking her head no. Ms. Waller-Pitts, do you have an off-taker yet for this project? And remind us when you hope to begin construction.
Thank you, Chair Sieben. No, there's no off-taker at this point. The site permit, obtaining the site permit will be a helpful way of kind of moving those discussions forward, right? And as of we sit here today, the plan is to start construction in 2028. Understanding, obviously, that a lot is changing with the kind of federal regulations, and so the company continues to actively evaluate that.
And do you have the components in, like, safe harbored or not yet? Or
Thank you, Chair Sieben. I'm going to toss that question to Mr. Krauzel.
Sorry, I'm trying to, Chair, Commissioner, or Chair. We have a program where we allocate to projects at the appropriate time. So not necessarily at this time, but given once we have release of Department of Treasury safe harboring guidelines over the next 2 weeks, hopefully, it's something that we'll be able to accommodate.
because you're a big enough company where I assume you have some component safe harbored nationally. And so if I can read into what you said, like giving you this, or what Ms. Waller-Pitts said, getting the permit will help signal to AEP overall that you're closer to ready to go to construction. So perhaps if the federal government doesn't totally mess up the rules, which it seems like they're intent on doing, then possibly you would have some components that could come here and work on this project. Is that a fair assessment?
Yes, Chair, precisely.
And if that all happens, could you begin construction earlier? Or, because I know the expiration of the tax credits is a concern, and the sooner you can start, the better. But what are the other pieces to that we don't understand?
Yes. So another factor that we're considering is on-site work. So that's something that would obviously...
With the workers here in Minnesota?
Yes.
They're ready to go, I think, right? If you can do that. So don't worry about that. We'll get you workers if you need them.
Very good. So yes, that's one option that we're exploring on this project, and that's something where the offtake agreement would also need to be, expedited in order to accommodate the requirements in this permit.
So say that one more time. The offtake agreement.
Yes, the commercial, the obligation, or the agreement that delivers our power.
You need to find a buyer.
Yes.
For it, and then but you've already committed. Is it accurate? You've already committed to using local labor to construct the project. It's just finding a buyer who's willing. You have to work out the negotiation on the components of the overall pricing, I assume?
Yes, Chair.
Okay. And is there anything we can do in our discussion here, or, general support of the project, as Commissioner Hahn brought up important components too, that would be helpful to helping signal to some of your potential buyers that we want to see this project go forward?
I'm sorry, I'm not.
It wasn't a really good question. Maybe, is there anything else we can do, Ms. Waller-Pitts, from the commission perspective to help advance the project at this point?
Thank you, Chair Sieben. I think the statements that the commissioners have been making today on this project and in other solar dockets recently have appropriately signaled the commission's support for moving projects forward.
If they're ready to go, especially, right? Because long-term, the point that I'm not making just to you as a AEP, but to the broader solar development community in the country is, in Minnesota, like, we really want to see projects move forward now to fully maximize tax credits while they're available, because that will have a really important impact on keeping the ultimate power prices that our customers pay more affordable. So the sooner we can get things going, the better. And I thank Commissioner Partridge for her leadership in the docket a couple weeks ago that was sort of related to this. And did you have a follow-up?
Thank you, Chair Sieben. I did want to follow up. First of all, I agree with Commissioner Hom, but I do want to thank you for your willingness to reconfigure the design so that you could accommodate Ms. Brazel and her needs as a landowner nearby. I think that was created a lot of goodwill for you and the company. I echo Chair Sieben's request that you do all you can to move forward quickly, and we do want you to get a buyer as soon as possible. And I just wanted to remind you, as Ms. Waller-Pitts probably knows, that we provided some extra favorable treatment for projects that come on and receive the tax credits related to their REC treatment, and provides a little benefit for utilities. So hopefully that is helpful in your process of kind of showing the benefits to utilities for signing a PPA if you are able to get the project up and running faster. And as stated here, workers are ready to go in Minnesota, and Minnesota is happy to have projects come on quickly to provide ratepayer benefits, which is really what we're here for. So thank you. That's all.
Commissioner Hom.
Thank you, Chair Sieben. This is just one suggestion. The last 2 weeks I was attending many meetings, and I learned that this large load is nowadays seeking load pairing with the generation, not necessarily at the co-location, because given the size of the renewable generation, so rather they want to pair with their large load with some renewable, given their intention to consume potentially 24/7 renewable. So given that, I think hopefully you guys can find those off-taker, and also hopefully some other onshoring, that the manufacturer coming back to Minnesota can take advantage of it, because these days I think energy and capacity is a big commodity to find, and I think Minnesota has a lot of potential, and I think you guys are providing the potential. So I think I appreciate that you guys are trying to build more renewable here, but also hopefully other business can see same vision with you guys, so they can build a large load along with the more generation. Thank you.
I just was wondering, and maybe I missed it, but where are you in the MISO GIA process?
Mr. Krasel.
Yeah, I didn't hear you say your name again. Sorry.
Crozel.
Crozo.
Chair,
Italian,
Commissioner.
Eastern European.
Polish.
Polish. Okay. Yeah, I was going to say Eastern European. Okay. Yeah. Sorry.
We're past decision point 2, so have received our second system impact study, and currently in our third system impact study, and expect to, MISO saying, I believe in a few months, we'll be working towards a draft interconnection agreement. Now, if anyone works in the industry, we're expecting that more next year.
I guess the question I have is, in the expedited, I don't know if ERAs would work in this instance, the expedited resource adequacy. I mean, you're kind of well along the way.
What about the super queue, right?
The super queue, yeah, the queue, the golden queue, as Commissioner Hom refers to it. But there is a mechanism for independent power producers to get an ERA's determination. But I don't know if that's just jurisdictional to the states that are only, the retail choice states. But I don't know if that's an option for you.
Mr. Krasel.
Brazel.
Krasel.
Like Dazzle, Brezel.
No, she was Brazel.
Yes, we're still exploring that option. Obviously, that's been released, I think,
just recently.
Yeah, in the last week. So We're exploring, the main challenge with that is having, there's a PPA, having a power purchase agreement signed before you enter that study process. So the biggest constraint that we have is honestly
not having a PPA, right?
Well, not having a PPA, but also I can't convince my internal folks to sign a PPA without a permit in hand.
Mm-hmm. Yeah, yeah.
But can independent power producers get into an ARIS designated slot without having Minnesota PUC approval? Do we know?
Well, I've never really thought of the IPP part of ARIS as something that could apply because it was done for the retail choice states. But if
someone
it could
asked
work,
me that yesterday, and I didn't know the answer.
yeah, if it could work, I'm not like
Ms. Waller-Pitts, are you
dogmatic about
familiar
it.
with it at all, enough to know?
Chair Steven, I can't add any more than what Mr. Krasel already shared.
Commissioner Hahn.
Yeah, thank you, Chair Steven. That's why I was encouraging you to find some off-taker, non-traditional off-taker such as a large load, onshoring manufacturing. I think there might be an unforecasted load, the portion of that ERAS. So I think that there is a way to make it happen, but hopefully your DPP3 is a lot better. But I think I heard that in recent docket that recent DPP2 is very favorable in general in Minnesota. So hopefully you get a favorable final result for your interconnection.
We need to ask MISO too, because just to clarify, a developer asked like what they had seen last week, how the commission made the designation of projects that were within our IOUs, but then we're wondering if they still needed to get designated or designation by the Minnesota PUC if they were an IPP. And I said I didn't know the answer, and now here it came up again. So we can ask, and then might need to figure out if we do need to do that, how to get on the list so that even if they don't make it this quarter, they can get on for the next one. So I guess we'll figure that out and let you know or be in touch with our staff about it if we can be helpful. Yes, Commissioner Tuma.
Just a couple things, wrap this up and land the plane. Thank you again, Ms. Waller-Pitts, for your work. I know it wasn't easy work that you had to do over the last couple of weeks. Appreciated, much appreciated. Good lawyering, so I keep up the good work. Just want to make sure I put a nail in that final coffin. You're committing here, my understanding is that you will build a facility such that it will coordinate with Xcel so that they can stay on the boundary lines, and that you're agreeing to a 20-foot setback so that your fences are going to be 20 feet back from neighboring property owners. That's the way the permit is drafted. Is that your understanding?
Ms. Waller-Pitts.
Chair Steven, Commissioner Tuma, I will answer that question, but first I just want to clarify that the kudos here really goes to the project team in understanding kind of the various infrastructure that's proposed in this area and being very thoughtful about their project and the surrounding community.
I was going to thank them later, but you
okay.
you can lead into it because that's good lawyering right there. So thanks.
And then with respect to the specific question, yes, I think the language that we had put in comments earlier this week and that's reflected in the motion today would accommodate that, and also it's the company's intent, as is stated in the application and elsewhere in the record, to meet the setbacks identified in the site permit.
And thanks for the company. I appreciate it. I think Commissioner Hahn pointed out we expect you to be community members, and we're expecting that. And we appreciate you seeing the need to be community members in this situation. I know you had the developer hat on before, and we appreciate that you had the community member hat on in the end and got to the right place. Mr. Refsland, I think, is on from Renville. If you could turn your camera on if you're still listening. Haven't fallen asleep listening to our boring discussions.
No, I'm still here. Thank you.
And
Excellent.
State your name for the record, please, and the organization you represent.
Sure. Scott Refsland with Renville County.
And one, thank you for your info on the setbacks. That was helpful to us so that we got clarity on what that meant. And so I appreciate that, and I'm sure Ms. Basil appreciates understanding that there'll be a 20-foot setback there, thanks to her county for doing that. So thank you for your
Brazel.
leadership. Brazel, I'll get it right someday. Every time I say it wrong, I'll owe Ms. Agramonte another beer, I guess. But thank you for that help. That was helpful for us to understand. I do also know that you have concerns about the decommissioning, and we are approving the decommissioning as we've normally done it for these large projects. It looks a little different than the smaller projects you do. But I don't want that to be an indication we don't anticipate your continued partnership in looking at the numbers and helping us out in that space, because this is on your community and in your community and would be your problem in the part of your problem, our problem in the end. We do view you as a partner in that space. So I just wanted to let you know, even though we're probably not doing exactly what you would have done in Renville County, we still want you to be involved and helping in that space. So I just wanted to make sure you understood that. And I don't know if you have any questions on that.
Go ahead, sir.
No, I do not have any questions. We have been in close contact with Birch Coulee Solar and their team, and we're confident we can come to an agreement that will be satisfied by both parties.
Excellent, and I appreciate that, and I'm sure you guys are going to continue to work with one of your leading community members there, Renville County. So thank you. They're nodding their head yes here, Mr. Refslin, so I appreciate that. That's it. And again, appreciate the commitment that you made on the property question with regards to power lines. So that is still the commitment, and they have agreed to the decision options. So I don't think there's anything more for me to add. So I guess I would move my decision options modified so that 69 is 115, but the rest of the decision options as presented earlier.
Is the motion clear for commissioners, or do you have any questions or comments? Seeing none, all in favor of Commissioner Tuma's motion, please say aye. Aye. Opposed? The motion prevails. Thank you very much. Thank you, Mr. Janisic and staff. We need a break before we take up the next two items. What about, do you think we can beat it back, commissioners, by 1:15?
Yeah.
The commission stands in recess until 1:15. The commission will come back from its recess. Sorry about the delay for everyone. And we'll take up item number 3. Mr. Noyce, please introduce the item.
Good afternoon, Chair Sieben and Commissioners. Item number 3 is docket number E002, E256/SA-25-192 involving Xcel Energy and the City of Kasota in the matter of the request for a tariff exception and City of Kasota service area transfer. The question before the Commission is, should the Commission approve a one-time exception to the kayak provisions in Xcel's Minnesota Electric Ratebook to cover the required service and meter socket upgrades and allow for service to be transferred back to Xcel Energy? We have party representatives from Xcel Energy and the Department of Commerce available for questions. Staff have no additional comment.
Okay, thank you. We'll begin with questions from commissioners. Commissioner Hom.
Thank you, Chair Sieben. And I have a question to department.
Ms. Campbell, welcome. Please state your name for the record.
Nancy Campbell with the department, and online I have Michael Bologna.
Okay. Yeah, I think my question is simple. So original department comment was a conditional approval. I'm just wondering whether Xcel's reply is good enough to meet your request for the conditional approval.
Yes, we don't have any concerns.
Okay, thank you. Then I can make a motion if there is no other question.
Commissioner Tuma.
Really quick, for the company, I assume the decision option is fine by you if we adopted the recommendation of the department, right?
Mr. Conlon, please state your name for the record.
Good morning. Good afternoon, Madam Chair, Commissioners.
Wish it was morning.
Yes, that is acceptable to the company. Riley Conlon on behalf of Xcel Energy. Yes, that is acceptable to the company.
Commissioner Hom, do you have a motion?
Yes. I make a motion to approve department's recommendation.
Which is filed on their June 5th, 2025 comment letter. Is the motion clear, Mr. Graham? Clear now. Great. All those in favor, or first, is there any discussion? All those in favor of Commissioner Hom's motion, please say aye.
Aye.
Aye. Opposed? The motion prevails. Thank you. Thank you.
Hey. No. Ripping out on the phone. You're having quite a conversation.
Jill Kringstead from North Dakota.
Ms. McShane, please introduce our last item.
Good afternoon, Chair Sieben and Commissioners. Item number 4 is docket number EG999/PR252 and the matter of utility cold weather rule and residential customer status data. The questions before the Commission are: 1, should the Commission take any action on the residential customer status data reported in docket number EG999/PR252? 2, should the utilities be required to develop disconnection and payment arrangement policies and make them public? And 3, should the Commission take any action on Greater Minnesota Gas's delayed filing of its cold weather rule report? The Office of the Attorney General filed a letter on July 25th with an alternative decision option 14. It has been shared with commissioners and hard copies are available at the front of the room. I have no further remarks, but I am available for questions. Thank you.
Can I get a hard copy, please, Ms. McShane? And thank you for that. And if the parties could please come forward, that would be great. And we'll start with appearances. There's not enough chairs, so we'll have to just share. Or you don't have to share chairs, but we'll have to rotate it in and out. But we'll start with the folks online, and why don't we begin with Otter Tail, please? Go ahead, Mr. Stephenson.
Good afternoon, Chair Sieben, Commissioners. Kerry Stephenson on behalf of Otter Tail Power Company, and also available today is Colin Kramer, our Supervisor of Customer Care and Outage Management.
And for who else is online? For Merck, Ms. Hoffman-Malik.
Good afternoon, Chair Sieben and Commissioners. Joylyn Huffman-Malik on behalf of Minnesota Energy Resources Corporation. I also have online with me today Dave Barron and Eric Schrader from our credit and collections area.
And I'm sorry, the other person online with your camera on, I forgot your name and can't figure it out in time to call you your name. Go ahead. You're on mute.
Sorry about that. Stephanie Bosch with Great Plains Natural Gas.
Stephanie Bosch.
Correct.
Okay, great. And Miss Anderson's also in the room. Are you the primary person for Great Plains, Miss Bosch?
Yes, I am.
Okay. And then, you're not Great Plains. That's right. You're Greater Minnesota Gas. I knew that. It's been a long day already. On my far right, Mr. Martin.
Thanks, Chair Sieben. Nick Martin with Xcel Energy. I have also here Riley Conlon from our legal department, and on the phone or on WebEx, Deidre Howard, who's the Director of Customer Care.
Go ahead, Ms.
And then, good afternoon, Commissioners. Emily Supwis with CenterPoint Energy, and then behind me is Jason Luce.
Commissioner Sieben, Matt Brodeen with Minnesota Power, and online I have Tina Kager, the Director of Customer Experience Operations.
Good afternoon, Madam Chair, Commissioners. Eric Swanson here on behalf of Greater Minnesota Gas, and Christine Anderson is also here from GMG.
Good afternoon, Chair Sieben and Commissioners. Brandon Crawford with the Citizens Utility Board of Minnesota.
Nancy Campbell with the Department of Commerce, and with me I have John Kundert and Tracy Semetna online.
And the OAG, are you planning to speak? Then you can use the middle mic just to... Is there anybody else who we didn't call on who wants to provide comments? Yes, go. I have no idea if it will work.
Good afternoon, Joey Cherniana on behalf of the Office of the Attorney General Residential Utilities Division.
Actually a little taller than that. So.
Good afternoon, Chair Sieben, Commissioners. Adam Heinen on behalf of Dakota Electric Association.
Okay, great. Commissioner Partridge, did you want to begin with questions?
Sure. Thank you, Chair Sieben. So I had a couple questions. I think they are primarily related to requests for additional reporting on the deposits that are required in some cases to be reconnected. So I think we have several decision options that pertain to that. I guess my question is really related to number 4, which is that utilities provide a filing explaining how they determine the amounts they require. Based on my reading of things, there was, I think staff and briefing papers mentioned that we do require currently in the template for some reporting on those deposits. And then CUB and LSAT replied that while that is in the template, you're not getting either sufficient information and I wasn't clear on whether the requirements in the template is not sufficient or if you aren't getting the information even though it's in the template. So I was hoping that CUB could provide some additional information on that request.
Of course, Madam Chair, Commissioner Partridge. So there's two related issues here. So right now, down payments, if a utility requires that, they can report it either as a percentage, a dollar amount, or as, either as an average dollar amount received by customers who make that down payment, or as an average percentage. That has resulted in essentially three ways that that information is filed. So CenterPoint provides an average dollar amount. Xcel provides the percentage that they ask from customers at the beginning of negotiations. So last year that was 50%. Now with Commission's changes to those down payment policies and practices, it ranges between 10 to 50% depending on if it's the first or fifth payment arrangement entered into. And then Merck reports as the average percentage after the endpoint of the negotiation. So we're asking first that it be reported both as a percentage and as a dollar amount, aligned with what CenterPoint and Merck currently report, just having it both ways, having consistency across the utilities. And second, related to those policies and practices, there is a requirement in the payment arrangements tab of the residential customer status report that requests and directs utilities to explain their policies and practices. For the most part, there isn't any information there. Some of the utilities do provide that, but most leave it blank. That's why we want that information to be included within those monthly filings.
Okay, so Chair Steven, if I can follow up. So to your first point, both 9A and 10A in the briefing papers reflect the request that utilities start reporting these down payments as a percentage of arrears and as a total dollar value on a consistent and standardized basis. Do you have a particular preference on whether we would, if we were to go this route, want that in the residential customer status reports or in the SRSQ dockets?
Madam Chair, Commissioner Partridge, we would prefer it to be in the residential customer status reports. That's where the information has already been filed on a historical basis. We're just asking that it be reported in both ways so there's consistency across utilities in how we receive that information and how the Commission receives that information.
Okay, and Mr. Crawford, this would be, so in briefing papers, it seemed like this would be sort of a change to the reporting template, but in fact, it sounds like based on what you're seeing today, this is something that utilities are, in some cases, already reporting and was already contemplated as ways that utilities should be reporting these down payments. Is that true?
Madam Chair, Commissioner Partridge, yes. Right now it's an or, but the kind of inconsistencies with how it's reported, I believe an and, is simply that minor change would be sufficient to have that information available.
Okay, thank you. So that would be for just keeping us all on the same page, because this was a bit confusing as I went through it. That would be 9A is what we're talking about right now. And then to your second report, or means to your second point, help me understand, is that your second point was about providing more information about the policies and practices? That would be decision option 4. Is that correct?
Madam Chair, Commissioner Partridge, that is correct.
Okay.
Within the context of those monthly filings, we are also asking for kind of separate one-time filing in this docket in 25-2, basically kind of encapsulating all of those policies and practices, both related to disconnections and payment arrangements, just to ensure that there is sufficient information, and then having that be published later on utility websites so customers can understand exactly what they're facing when going through a disconnection process or trying to enter into a payment arrangement.
Okay. To clarify then, if I can, Chair Sieben, number 4 is that one-time filing, and based on my reading of the record, all of the utilities, I think, have said they are willing to submit that information to the record, and we can ask the utilities to comment on that, or maybe to just come forward if you disagree or something, because I don't think we need lots of comments on it unless others feel differently. But am I just getting it right?
Madam Chair, Commissioner Partridge, I believe decision option 1 is the one-time filing.
Oh, I'm sorry.
And then decision option 4 is just to capture that within the monthly CWR filings that are submitted by utilities. We don't expect it to be an extremely long thing within those monthly filings. It's in an Excel sheet. So just something very simple, perhaps including a link to these policies and practices that they host on their website at a later point in time. I'm very, very familiar with these filings. Someone viewing it for the first time might not know exactly where to find that information. We wanted to make it as easy as possible to understand what is being done and why those down payment amounts are being required.
Okay, so number 1 is the one-time filing, and 4 would be to add this as ongoing information. I guess, sorry,
It doesn't really say that in the staff modification, so that's why it was a little hard to understand what you were actually getting at, Mr. Crawford. So, at least the way I read it. So, one more time, number 1 would require a one-time explanation 30 days after this, or whatever, after the order comes out in this docket. And then number 4 would provide a link to how that is determined
Madam
on
Chair.
each utilities IOU's website.
Madam Chair, yes, that's one way. So basically right now, the monthly filings have a line that says explain practice if they require a down payment or service deposit or something of that nature. I think having a link to their website or something like that is probably the easiest way to do it if it's, if it doesn't fit on a line or two of an Excel sheet. If they're able to put it into those spreadsheets, I think that's great too.
Did the other parties agree with that assessment, Mr. Crawford? Do you know, either from like your interactions with them prior to this, or is that kind of the general direction you're pushing here?
Madam Chair, my understanding is there's no opposition, but I also do not want to speak for the other parties. I think this is a relatively simple change, especially if you move forward with hosting it on the utility websites. It would just be a very minor thing.
Does anybody here object to Mr. Crawford's, like, the way he and Commissioner Partridge laid it out, and think that that's a bad path forward that you want to comment on? Okay, great. Commissioner Partridge?
Excellent. So what I'm looking at is 1 through 4. Number 2 provides a little nuance because Minnesota Power has already provided some documentation, and they would like to just sort of tweak that to be a more customer-friendly facing document. So number 2 is just sort of a one-off, but 1 through 4, it sounds like people are generally okay with. Excellent.
And Mr. Brodeen, is that your understanding with what the staff interpretation of your suggestion is in 2? And is that what you were saying you would do?
Chair Sieben, yes, that's correct. That we would file something similar to what everybody else would file, but it would be more of a summary of what the more extensive report that's already in our record in a different docket would be.
Great. Commissioner Partridge?
Excellent. And so with that, I do have some new proposed language. This language would just consolidate some of the decision options for us going forward. So I'm going to we'll put that on screen. Here's hard copies to pass out to my fellow commissioners. Let me just pull up something to make sure. I was working on this morning, so sorry for the okay, let me just. Okay, so the proposed new 8, what this attempts to do is to.
Sorry to interrupt. Is this in addition to 1, 2, and 4, or is this instead? Okay,
yes.
Just making.
So my proposed new 8 would combine and replace decision options 5, all the different decision options we could have considered in 6, and 8. So it would be paired with 7, which is to say that the utilities should work with the CAO to come up with language. So let me go to that. So number 7 says, work with the CAO to find customer-facing language on disconnection, deposit, down payment, and payment arrangements. And the new 8 would say, make sure that you're displaying that new language that you work with CAO to develop on your website and in printed communications. And then we aren't determining specific language or wordsmithing anything today, which was what was happening in 6 and all the different subparts. We're just saying, you all work with the CAO, come up with language that the CAO thinks would be most appropriate, and then make sure you're displaying that on your website, which is where you can link for the requirement we just talked about in the template on those monthly filings. And it's there for your customers to find and access.
Does anyone want to comment on Partridge New 8? Possibly Xcel. They're moving around. And Mr. Heinen, you're welcome to provide comments or questions.
Good afternoon, Chair Seaman, Commissioners. I'd say, sorry, I speak into it. After last week, this mic was acting up. I'd say overall, Dakota Electric doesn't see an issue with this, and maybe this is me wordsmithing, or not wordsmithing, some grammatical suggestion. Is the last sentence felt a little cumbersome with practices must at a minimum? Must might be superfluous, and we could move at a minimum after include. So that's just my sort of grammatical suggestion. But
I also was wondering, and I'm just noticing it now, the former politician here speaking, must include at a minimum door hangers, Commissioner Partridge?
I think that,
that's
that was
too much.
That was in the existing 8, and the reason I didn't undo that is because it was my understanding that I don't really know what the door hangers are. I think that they put those out when they're about to disconnect. So the door hanger that you get when you come home with a disconnection notice would say, here's how you...
It's not a new practice where
No.
they'd be providing it to just anyone.
Right. They put door hangers on people's homes when they're about to disconnect them.
You just say disconnect door hangers, that might be better. I was thinking it was like a campaign they're running around giving everybody a door hanger. I was the same way you were.
Sure, disconnection. Probably disconnection notices include the door hangers, so we probably could take those out. I just was leaving as much of the existing language there as I could work with, but. And I don't have a strong position about whether must and, should, I think it's fine. I don't know what, you'd need some sort of verb there, so, I don't know.
Practices must include disconnection notices and bills.
I'm not sure what Mr. Heinen wanted. I think he wanted must removed, but I don't know that I was following. Okay, well, I'm open to whatever.
Mr. Conlon.
Thank you, Madam Chair. Madam Chair, Commissioner Partridge. Our concern was similar to what the chair flagged, and it was around the door hangers. As long as it's disconnection related, I think Xcel doesn't have a problem. I think what we've thought about is there are other types of door hangers, whether it's construction related, something like that. So we just want to really tightly focus that.
Sure.
And so flagging that for consideration.
Yeah, I think that's a good flag. These are very specific to people who are receiving various notifications that they're about to be disconnected, is what I was envisioning.
So I think it should say, and this is the danger of wordsmithing on the fly, printed disconnection communication materials must describe service deposit and payment agreement policies and practices, period. right? Isn't that what we're trying to do? Make sure that the disconnection printed materials contains like the information you want it to have, right? Mr. Crawford?
Madam Chair, that is correct. I think I would just say the disconnection and payment agreement policies and practices, making sure that all of that disconnection information is included there. And I fully support working with CAO to develop this language. We did discuss the recommendation 6 that we had brought forward previously, and they mentioned a desire to have some consistency across utilities when it's on their website. Really appreciate that, and appreciate the direction this is moving.
Yeah, and if I can just specify, so the language on these different notices, I believe, was introduced by CAO, which is why I left it. So I
think we have to make it so we can understand what it's saying. So if you're okay changing it like this, I think it's a little clearer.
I don't know if it is.
Order.
I guess that's my point. But I think it's fine as long as I just want to make sure that whatever disconnection notices are being given to people include that information. I think CAO was saying that having it on the website isn't sufficient. So I think it's fine.
Are they here? Or do you want to take a break so you can talk to them, Ms. McShane?
Chair Sieben, we can certainly take a break. I know that Ann is here right now.
Okay, well, the commission stands in recess, and let us know, please. Or we'll stand in recess for 5 minutes and then come back. The commission will come back from its recess. Commissioner Partridge.
Thank you. We confirmed that CAO is supportive of the language that's up on the screen modifying my modified 8. And so that would be my proposal, is to kind of combine the existing decision options within the briefing papers of 5, all of the things considered in 6, and the old 8 into this new 8.
Great.
7 would go with it because it says they have to work with CAO. So I think we need both those.
And then, should we keep going through the, or is that like an all-encompassing motion?
No, that is just, so I think that they were kind of categorized in different things. So I think that would just take care of transparency and accessibility. I think we've talked a little bit about number 9 versus 10, and that would be essentially a very minor tweak in the current template, which is under additional data. So I think
what about commission, oh, sorry, and then are you going on to 12 or 13? Or were you skipping that?
So 13, include a prompt.
I don't know what a prompt is, but I didn't ask Ms.
Oh.
McShane that ahead of time. I assume that just means a question that's going to be in the notice, Ms. McShane? What's a prompt?
Chair Sieben, yes, that in the next notice, which would be coming in September 2025, the question would be included in the notice.
Okay.
What's the question? To explain what is their complaint resolution process?
Chair Sieben, what
What is
decision
number,
options?
you offered number 13, and I'm trying to understand what you're getting at. I think what you said is that it would be a notice in the next comment period to ask all the utilities to explain their complaint resolution process. Is that?
Yes.
And then they would file in that, so that then you would, I don't know when we'd get their response, but it would come up in this docket next year?
It would come up in this docket probably late 2025.
Okay. Did the utilities think that or want to respond to? Or Commissioner Partridge, I don't know what you were thinking, if or who thought this was a good idea to do. Anybody think, is anybody especially supportive of 13? Where their complaint resolution process isn't clear now and we should ask the question? Maybe we'll skip it then. Okay, then now we're on to Greater Minnesota Gas decision options. Commissioner Sullivan.
Thank you, Chair Sieben. I guess, Ms. Anderson, I'll just kind of, to Cub, it feels to me like I've reviewed the correspondence between Greater Minnesota Gas, and I reviewed Cub's comments. Feels to me like there's been a very clear recognition that there was a mistake. The company has made changes. It feels also like sending it to the Attorney General is pretty heavy-handed. So anyways, Mr. Crawford, if you want to, it's your recommendation that we send it to the AG, and sometimes we have to do those things. See last week, sometimes everybody gets the point and we don't. So,
Mr. Crawford.
Chair Sieben and Commissioner Sullivan, I do think this is a little bit of a unique situation. That information was not reported for an entire year. And I think that's extremely concerning if, customers aren't provided information, if disconnections are rising. We don't know that. And that's the sort of situation where we do want to prevent anything like that from occurring again. We recognize it's up to the commission whether or not you feel that is the appropriate action to take. But based on the statutory and rule kind of framework for this, we recognize that that was not filed. We do appreciate the kind of corrective actions that have been taken at this point in time and hope that it does not happen again. But other than that, this decision is up to the commission to make.
All right, Ms. Anderson, if you want to give a little bit more color around, responding to Cobb, I'd appreciate it, but in particular, there's the reference to knowingly, where is it? I don't see it here in the decision option, but there is, I'd just like to hear from the company a little bit more on your explanation for it and,
Ms. Anderson.
Thank you, Madam Chair, Vice Chair Sullivan. First and foremost, I readily admit there were mistakes made, and I will take the fall. I should have been more on top of paying attention to how things were happening. We all wear a lot of hats in that company, and I'm not trying to excuse it and play the size card. The fact is, we are a small company. We all wear a lot of hats. There had been a discussion about some of the regulatory things coming off of my plate and going elsewhere within the company, not by anybody who's a direct report to me. And I should have kept a better eye on it than I did. When I would be contacted about something not being filed, I would pass it on, talk to the supervisor of that group, and be assured that things were being taken care of and being done correctly. I dropped the ball by not staying on top of it. I readily admit that. We also had some staff turnover, and when we went to recreate reports, realized that a lot of the data collection or the information that had been being collected for the report but not being filed was bad data. It hadn't been being done correctly. What we have done in the interim between then and now is put together new policies, not just with respect to cold weather rule, with respect to some of the other regular reporting items as well. But we examined our policies, we put together new policies, we took the whole customer service group that is involved in maintaining different pieces of the data or working with the different things that feed into the monthly reports, put them all in a room, walked through everything. We've explained everything, explained the significance of everything, because we want to create a sense of investment in the people that actually work with that data as well. We've put new procedures in, and whatever you want to call it, old people like me and maybe some other people in the room used to call it a tickler file. Now that's probably not politically correct, so you call it calendar entries or tasks or whatever. But
you said it though.
I knew what you said. Yes, too. But I'm old. I got mammed 3 times yesterday, so I get to say things like what we used to call them. We've done that, and to be perfectly frank, I've returned to being the control freak that I used to be, and I've pulled it back so that all of the regulatory items come across my desk to go in. And I had been remiss in not following up. So I think we have put in place the mechanism that we need to make sure that this stays corrected in the future. We certainly take it very seriously. We have, with each of the 3 months since we've made those changes, done debriefing. I've done debriefing with the staff as recently as yesterday, and with the supervisor of the group that maintains the data. But basically all the data goes now to both her and me. And that team has also been told to keep me accountable I am also required to identify on the calendar when the filing's been made, and the staff has been asked to keep me accountable. So if they don't see that it's been made. So we think we've put the tools in place.
So I, thank you, I understand. I mean, you know, Mr. Crawford does make a good point, a persuasive point that, you know, had something been going on, we wouldn't have caught it, you know, for 2 years. And, I mean, you don't need to respond to that, but I do think that that's an important point. That's why we have filings, and, you know, and the public has a right to know about this information. So I appreciate that you are on top of it and that you've made the appropriate internal controls, the changes to internal controls. I guess I'll turn to the Attorney General. If it were to be sent to the Attorney General, what would be the AG's response? What would your office do?
Yeah, so the law is that if there's a knowing and intentional violation, the company can be fined between $100 and $1,000 for each violation. So the question is, and that's, so, you know, I clarified in my letter that we're letting you decide. I think that there's enough evidence to find, yep, go ahead.
Oh, no.
Okay. I think there's enough evidence to find, you know, what we heard is about future stuff. There is enough evidence to find that the failure to do it was knowing and intentional.
Why was it that?
Sorry?
Why was it? I get that it's knowing now, but why do you think, where's the evidence that it was intentional? That they...
Yeah, so...
I didn't follow that.
Yeah, I think one of the biggest things was, you know, we asked for more details about each of the different allegations, and the response was effectively, you know, what's done cannot be undone, but we're going to move on things going forward.
Sorry, I didn't read into this as much as I should have. Did you ask those questions just like this week? Or
no,
in
it was
responses as you knew they
discovery.
weren't
Yeah, as we learned before. I'll just say, you know, again, it's up to you. If it's all laid out in our comments,
Can I
all of the
just clarify something there?
Yeah.
Was it rolling? Like you were like, okay, 3 months in, why are we not getting this? Ms. Anderson responds.
Good question.
You know,
Yeah.
8 months in, we're still not seeing this. Ms. Anderson responds. Like there's a trail of, so that you can make the argument that it's knowing and intentional. I mean, like knowing and intentional has a certain connotation to it, and I'm a lawyer, so it does not mean like you were being great or yeah, I mean, it means malfeasance is the way that I think of it. So,
or deciding not to do it, I think is the way that I would put it.
Additional malfeasance, yes.
And yeah, I mean, sorry. So what was the question?
The question was like, how did it roll in? How did it?
How did it roll in? Yeah. So during the rate case, we were trying to look at disconnection data and affordability data, and our analyst looked, and this was only in April, after there were some allegations made in the rate case that we wanted to double check, and we weren't able to verify that because we realized there wasn't the information there. And then that was actually just a few days before Cub independently had they filed their comments, and they had noticed the same thing because the stock was coming around.
So then back in April, you notified, or your analyst or someone in the rate case said to Greater GMG, like, by the way, you're not filing your, this, what are these called? These weekly reports as required, or your monthly reports. And then the company's response was basically like, not to amend it and fix it then, but
right, there wasn't
told you
a response.
Just like they didn't respond. And Mr. Swanson, you're disagreeing, so
I am
please,
disagreeing.
Please, well, give me your, or maybe it's in the record and I just don't see it, but like what is the sequence of events that would demonstrate that it was, that you knew that the company wasn't filing the reports and you yet you chose to continue to not file the reports.
Madam Chair, Commissioners, Eric Swanson on behalf of Greater Minnesota Gas. As Mr. Attorney said, this came up in the rate case. That was in April. I'd just refer you to the May 14th letter that Ms. Anderson filed that explains the steps that were being taken, the work that had to be done to make sure the data was correct. I don't think the company dragged its feet at all here. It sucks that we're here talking about this. It's bad that we're here talking about this. The company's acknowledged that. The company's taken responsibility for it. I would hope that we could move on.
Okay, well, I think we're trying to, or Commissioner Sullivan was trying to get to the bottom of it. So in April, you noticed that, or you heard that you weren't doing the reports. In May, Ms. Anderson replied. And then when did the reports start coming in? Now it's July, so there's not that much time to get all the reports, but.
Madam Chair, Commissioners, when Mr. Cherney made said that they'd asked us for information that we didn't give, the kind of information that was being requested, a lot of it was historical names of people that were responsible for collecting the data and things like that. We communicated in conjunction with Mr. Swanson. It was in information request format in the rate case. We replied that a lot of that information we felt was outside the scope of the rate case and not relevant to the rate case, but we did then address the cold weather rule piece of it, or the residential monthly status reports. Sorry, I got my words mixed up, but in the cold weather rule docket. We started then going back through the reports to look at them to find out confirm what had been filed and what hadn't been filed, instead of relying on what the internal notes said, right, to actually look at it on the commission's website. As explained in my May 14th letter, when we made the filings to bring everything current, we had to go back. That data was bad data, so we had a lot of rebuilding of the data that we had to do to make sure that what we were providing was sufficient data. And we acknowledge that the public has a right to this information, and we acknowledge that that didn't happen. As staff pointed out in its filing a couple of days ago, when they went and did the analysis, because all of our information is in and was in May and has been current since then, it's clear from the disconnection data that our practices haven't changed. Just for your information, in the last cold weather period, so October to April, we disconnected a total of, I think it was 6 people in the cold weather period. In the whole calendar year of 2024, I think it was 42 or 43 people in total, at 40-ish in the summer months. So we don't have large numbers to begin with, and I'm not using that as an excuse. I'm just saying we went through and we did a manual process to go through and verify all of the data that we were reporting. So we did it. It took us about a month to get it all in. It's stayed consistent since then. And it is true that we objected to the breadth of some of those questions in the rate case on the basis of the fact that it wasn't relevant to setting rates in the rate case. And quite frankly, as I said in my letter, we can't undo what happened. And going back and naming names of people who are junior people in the company and may not even still be in the company, I'll die on that hill. The buck stops with me. I just was negligent in not making, in taking the word of other people for things that I shouldn't have.
Commissioner Partridge.
Thank you, Chair Sieben. So just to recap, I think important information here is that you were notified in April that those reports had not been filed, and that by the end of May, we had all of the information and the data. I think, I struggle with the idea that this was knowing and intentional just for a couple reasons. One, that as soon as the company was made aware of it, they provided all of that data. I agree, it's unfortunate and it's important that we get that information, but I still think it's a stretch for me to think that they were maliciously not providing that data. And one of the reasons is that I have reviewed the data that was submitted, and I think it is worth mentioning that GMG has notably low disconnection and a notably low number of past due accounts. And so if they were going to hide information, I'm not sure why they'd hide information that we'd praise them for. So I think, my take is like, Ms. Anderson, I appreciate you actually taking responsibility. I appreciate that you're not throwing a junior analyst under the bus for this. You know that this is not good, and we expect that you won't let this happen again, and that's kind of where I'm at.
Commissioner Hom.
Thank you, Chair Sieben. Yeah, I think this is a systematic failure. Yeah, the company definitely failed, but also I think receiving end didn't check. I was very surprised at how long it went without from receiving end was a checking. So I think we have to revisit and to see what was the intention of collecting this data and why we couldn't catch this earlier, so we could have corrected it if that is necessary. Or do we need this weekly data if you are not using it? I think we have to revisit overall big picture why we are doing this. And so my concern is, yes, whether there was an actual damage to the customer, as Commissioner Patridge mentioned, that based on data, it wasn't negatively impacting ratepayers. Being said, I think we must have a reason to implement this one, but it was not properly ran on the other side. Company, yes, but also receiving end, we didn't do our job. So I think we may need to fix something. It didn't work.
Commissioner Sullivan.
I mean, from my perspective, I think where Commissioner Partridge is at, I'm assuming message received. I do appreciate, CUB and the AG, raising this. I think it's important. Compliance reports are done for a reason, and they're important. But I think the company has the message, and my sense is when we get to deliberations that we don't need to refer this to the Attorney General's office. I think that there are more important things for the Attorney General to be working on right now, especially in the energy world. So that's my sense.
I appreciate too, Mr. Attorney, that you wrote in your letter last week that that you signed this, right? Yeah, that the RUD defers to the commission to decide the best course of action to ensure future compliance, and hopefully, I think you gather from all of us that we do really want, and we trust that the company will follow the statute and file their reports as required going forward, and appreciate that you brought it to our attention, and hopefully this is enough to course correct.
I think it's probably more than enough that we've punished you already, so thank you for being proactive, though. That's what I think.
Commissioner Sullivan.
When we're ready to move on, I did want to talk about decision option 15 and other topics that CUB has brought forward. That seemed like a pretty good idea to me, and I kind of was wondering why folks, it feels to me like the price of that is the price of ink, not much. And these are projects, or these are measures that can potentially help people, especially as we look at affordability issues. And I saw no reason to not include it, but I guess I'd turn to the folks who weren't crazy about it.
Mr. Martin, we'll start with you on the right.
Thanks, Chair Sieben, Commissioner Sullivan. We certainly have no problem with this. We strongly support trying to increase participation in eco programs, and our folks in the eco team are working on that. It's actually the main topic that we're discussing with our Environmental Justice Accountability Board as well. So the intent of this we're strongly behind. the only, concern we had about it is that, this is information that we would report each June in our eco annual reports. So we thought we kind of agreed with staff that it's duplicative, but if the commission wants us to sort of include that same information in the affordability reports, which are at a little different time, they come kind of early in the year, we could certainly do that. So we don't have any strong opposition to this.
I appreciate that, and I'll get you, Ms. Supas. I mean, I appreciate that. Sometimes I think there's a value in duplication, and that's my, like we bring things in under another venue so that we can focus on it and make sure that we're doing it, even if we talk about it in another place. So I mean, I hear what you're saying, and sometimes I just see value in duplication. Ms. Supas? Not that you disagree with that, but I'm just...
Thanks, Chair Sieben and Commissioner Sullivan. So we also agree with the intent. We've also already agreed to provide this duplicative information in our gas affordability report. So this would be the third location. Again, we're happy to provide it and understand that it impacts many different dockets. It's just that our reservation was, again, that this would be the same information in 3 places.
But I don't think we have a problem if it's the same information just filed in 3 places either, right? So it shouldn't be, it's sort of like a cross-filing then, almost? Is that?
Cut and paste is what I was thinking.
Yeah. Is that the idea?
I'd be curious, where would we take action on this information more than likely? I guess that's a docket I wanted in, but I guess.
What would be in all the dockets?
But this one?
But I think to Commissioner Sullivan's point, like having it in here sometimes might be a better reason for us to focus on, why people should have access to heat pumps or something too that are available through. It would be a good, like encapsulation of you do this. It could help you afford your bill more type thing.
Mine was actually just a question of stupidity. I didn't know where we would act on it. I don't know if it'd be an eco docket or in this docket. So Audrey's saying here, and I would guess I would trust her opinion. So on eco.
Commissioner Hum.
Thank you, Chair Sieben. Usually I agree with the approach that more is better, but also I have a concern that we have already seen that small utility having trouble keep tracking all of these compliance. So I'd like to ask Greater Minnesota Gas, but it's a doable or not.
Ms. Anderson.
Madam Chair, Commissioner Hom, we are also of the same opinion that it's duplicative information because it's in the eco reports now where there is a specific section that talks about low-income programming. So there generally is a narrative in that. Decision option 15 actually references the affordability program reporting, not cold weather rule. So I guess I just wanted to clarify, even though we're in a cold weather rule docket, this really is asking for it, the information in our annual GAP reports, our annual affordability reports. We do a little bit of a high-level discussion of how we reach out to low-income customers in the affordability reports anyway, and I would venture a guess to say that the other utilities do. So I think we certainly could do that and make sure that that's added to our GAP checklist. To Commissioner Hom's point, I think where there sometimes is some difficulty that comes into play with duplicate reporting and cross-reporting in multiple dockets, you especially see in a case like this, where this order is going to come out in the 25-2 cold weather rule docket. But one of the order provisions, if decision option 15 is passed, is not about the cold weather docket, it's about the GAP dockets, which is a completely separate docket. And so when you have reporting requirements and compliance requirements being issued for one docket in another docket, it becomes very easy to see where one of those balls could fall through and get missed. Not all of us can juggle on a unicycle. So I know that one of us can. The man to my right, that's the fun fact about Mr. Swanson for the day, but not all of us can. So I do think that there's danger in having multiple reporting requirements sometimes, but with respect to this one in particular, I don't think it creates a problem.
One solution that I just asked Ms. McShane is if the staff could cross-file it. So if you're already doing it, like in the other two, the GAP and the ECO, then staff could pull those reports into this docket going forward. And then it's a little less, like, we're not gonna be back in the situation of someone's mad that the utilities didn't do what we told them to do. It would be, but the info would still be coming into the docket. That's, I'm just trying to be, if that's a solution, it might work.
I mean, that works for me, if it becomes part of the record and becomes part of the discussion, that seems like a workable solution.
Can I ask a clarifying question? In that case, I'm just trying to jot down in the current motion as we go through it. So then we wouldn't include 15 and we wouldn't have to do anything for staff to cross-file. Is that right?
I think, or we could say require staff to include in their next annual affordability program docket, a description, or,
sure,
you know, essentially we're just memorializing it by saying staff is gonna pull that filing, because I think the intention was only for the next docket anyway, right? It would, you just have to remember to do it one time, staff would. Is that right, Ms. McShane? So I don't know if we need a motion or not then, but just do it internally, or Mr. Davis can put in the order, whatever you think, but.
Okay.
Does that work? I don't know what I just said.
That makes sense. So.
I do, so.
It may or may not
You good?
happen.
I also
Show
knew I
up
was
in
gonna ask
order.
my wife for my next birthday party, though. Juggler on the unicycle.
Okay.
Commissioner Sullivan, then did you want to keep going between 16 or 17, or?
That was all I had. And whenever we're ready, I'll be ready to discuss a motion or whatever.
Did other commissioners have questions related to the remaining issues listed in the, I don't know where we're headed in terms of a motion, that's why I'm pausing. Like related to the other issues raised in 17 through 22?
I have one for, I have a question on 21, but I don't have anything for the others. Okay, thank you, Chair Sieben. On number 21, there's a request for some additional data in 21A related to deposits for, or down payments as a % of income. I'm wondering for the utility is this data that you can get or have? Is it okay if Mr. Martin starts?
Mr. Martin.
Thanks, Chair Sieben, Commissioner Partridge. We did have concern about this one. Of course, it only says, gives us the option to explain why we couldn't do it, so that's there. So, but we did have a concern because we really don't collect income information or retain income information for all of our customers. We have implementers of our affordability programs that require income verification that do that for us. We do get some information, so we might know, for those that are getting LIHEAP, that their income is less than 50% of the state median income, but we don't know what their actual income is necessarily. So we think it would be difficult for us we wouldn't have the denominator for this calculation, basically.
Okay. And I'm seeing head nods from other utilities. That was my sense. That's why I wanted to just clarify that.
Yeah, a very good point. And I was curious because I heard there were some issues with regards to whether LIHEAP can be we can lean on LIHEAP like we have leaned on it to determine eligibility. And so has that changed, or I just remember reading something about it. So I'm just curious whether we're going to have an issue and whether we should be having a discussion about low-income eligibility verification.
The funding from the federal government hasn't been completely eliminated yet, but I think is still at risk of that happening. Is that what you were asking?
Yeah, well, I heard, that LIHEAP, we may not be able to lean on it, I guess. That's what, you know what I mean?
Yeah, that's right, Commissioner Tuma, and your staff can tell you about this as well. That's true. There is uncertainty. We don't know yet about LIHEAP funding in the coming year. There's concern about it still. And because of that, there was, legislative changes broadening the definition of low-income household for the purpose of our affordability programs that would make LIHEAP just one of three options.
That's right.
And the staff has opened a docket where we're starting to discuss that, like how we would implement that. We're very interested in, ways we might be able to.
That's what I was thinking about. Thank you for clarifying. I remember something about it, and I wanted to make sure we're not missing something. We're not. I'm ready.
Okay, who wants to make a motion, then we'll hear from parties or commissioners after we hear what the motion is.
I'm happy to make the motion. So thanks to my colleagues for the questions that answered my remaining questions. So my motion will be decision options 1, 2, 3, and 4, as laid out by Commissioner Partridge. Then I will move decision option 7. Commissioner Partridge's new decision option 8, modified. Then I'll move decision option 17, 19.
Wait, hold on. $17.
19. Decision option 20. And then as I guess as far as the last conversation around decision option 21, I guess my sense was that to not move decision option 21. And so that's my motion for discussion. My feet are not in concrete.
I wanted to, on the issue of how utilities communicate with people who can't read in their native language, it seems like a good idea to, again, prompt you to explain to us how you do that. And then my understanding of what this means is you'll tell us like how you communicate with people that might not read. And so I'm just wanted to make sure that you're comfortable with that, with decision option 17. Mr. Martin?
Yes, Chair Stephen, we're comfortable with that.
Maybe, is anyone uncomfortable with it, I should ask, so we do this faster? Okay, good deal, helpful. And then I'm just catching up. Is anybody uncomfortable with, it was a staff recommendation, but we didn't hear from the parties about 19 or 20, that they wanted to raise concerns? No? Okay. Commissioner Partridge?
Thank you, Madam Chair. Commissioner Sullivan, I have one friendly amendment for consideration, and that would be 9A, which would require that the utilities report their down payments that they're requiring both as a percentage of arrears and total dollar value, just to clarify in that template.
Yes, sorry,
That's okay.
did not include that in there, but thank you. I have that circled. For the record, I have that circled in my notes.
So Mr. Davis has that. Mr. Davis has that incorporated into the Sullivan motion. Any other questions or, keep forgetting to ask the people online or look to see if they had comments. Anything online from folks where the motion isn't clear, you want to weigh in? Okay, hearing nothing. All in favor of Commissioner Sullivan's motion, please say aye.
Aye.
Aye. Opposed? The motion prevails 5-0. Great. Thank you, everybody, staff and parties, for your good work on this docket. We appreciate it. There's no other business before the commission today, so we will adjourn.